trial where Mr. Brooks has the right to present relevant and probative evidence.
We're back and he's in the penalty box.
And I have done my very best to honor his rights in that regard.
He's in the courtroom next door because he can't behave himself.
Part of this morning dealt with his, from my perspective, disagreement with how I yesterday and in the days preceding that set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit, as is my not only right, but frankly, my obligation under 906.11 to make sure that there is an effective presentation of evidence.
Oh, Lord. This is
exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation.
Talk 906.11 to me, honey.
By judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any manner relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness, except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect.
Where does the court go? You're muted.
Mike, you there? What's going on?
Hello, Earth to Mike.
All right. It's been day drinking already? What's going on?
It is true.
All right.
I have not been day drinking. Practice of
I just hit the wrong tab.
Any preliminary issues that the parties wanted to address.
We'll get through this, people. We'll get through it.
In my mind,
I wanted
to get to the witnesses.
I look like your cousin.
We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure
I heard you too. I'm like, I got a screen to share. One thing at a time.
Reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time.
Ben, you got to figure out something about your audio. It sounds like you're coming through a voice box.
The decorum, or frankly, the lack thereof for many days on end throughout this trial.
I really did, Beverly.
It has become apparent that when the jury comes into this courtroom and leaves this courtroom that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision that I have filed in this case. It is very clear this court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a
Ben gets thirst.
Type of issue that comes
John gets
up,
ginger.
but not under the circumstances. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted. I brought him
when he is
stated this way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions,
the other room,
disrespectful behavior, the common courtesy, I think that just as a human being we all would expect, have not been followed. I have
in the penalty box. He's got a 5-minute major.
Let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay,
also the perspective
to disrupt,
of everyone at Law Talk with Mike's
or
chat.
just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record.
Rapidly.
Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as
he's reading a Bible.
Exchange went on. From my perspective, he got
Anna.
I love my chat.
More disrespectful. I think it's fair to say his behavior was volatile, and it's because of that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. It is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses.
Once they get onto something, there's no stopping them.
He pushes the limits.
I can see that.
Asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question, basically? Is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other acts evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate
Chats, I would love to visit Nova Scotia.
The trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling. That leads to the evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906.16 and 906.08. Those are generally two of the statutes.
I think Judge
dealing
Darrell
with
wants
character
to kill
evidence. That would be
herself.
906.08, 906.16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character, as a mother, which is wholly improper. The only character evidence that would remotely be allowed under, at least for a witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906.16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erica Patterson, and then the photos. The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant.
He's
not
screaming at the
any
camera
reason
and he's
as to why it's relevant.
at like 10% volume. It's
the state
amazing.
also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him related to the other acts evidence, related to whether he has a relationship with the children or not. And frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not
He did
relevant.
it.
It is not probative.
He opened it. Are you kidding?
I think she's going to let him back in.
But
She just did this
certainly
to make this
One
record.
could argue, based upon the questions,
Yeah, I agree. Should let him back in.
could be opened to.
No, let him in fine, but he kicked
It
in
is
the
my
goddamn door.
duty as the judge assigned to this case to ensure that the trial is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses.
Fine.
And so I'm not going to allow questions related to the children in common or child in common, at least
Let
any
him
further
fuck
between
up.
Mr. Brooks
He's allowed to do that.
and Ms. Patterson, when they met, how they
He
met,
chose to represent
the
himself.
nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong. That needs to include an offer of proof as to why he believes this letter is from Erica Patterson and why it's relevant
No, nobody's going to
to
tell
the
me to
issues
calm
in
down.
this case. Because he came in to the courtroom this afternoon and is not in here, but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the Supreme Court in Illinois versus Allen stated, it is essential to the proper
I think it's because he's in the other room.
that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it.
Great record, Judge.
I would remind him once again of
She's
SCR
gonna let him
Chapter
back in.
62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them
No,
do
no,
unto
no,
you.
Oh,
no,
good
no,
Lord.
no,
Be respectful.
no, that's bad.
Be kind. Give these proceedings the due respect that they deserve.
Golden rule is
For himself.
explicitly excluded.
I do not
I
believe
forget what Supreme
he
Court
even
case.
shows respect
No,
for that.
no,
I'm not
don't
looking
create an
for
opening.
any further input
Oh,
on
God.
the issue of removal or any further
I
record.
like this judge a
I
lot,
wanted
but
to
he's
make that record without interruption, which is why Mr. Brooks
without. Oh God.
was in the other courtroom.
No.
When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the record for that momentarily. An offer of proof if he wishes to do that related to the letter and further questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself.
I'm trying not to drink, but
The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? October 7th, I believe she was the third witness.
She's not handling her courtroom well.
Glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness.
April is
At
because
this point in
it's
time, does the state anticipate any
inappropriate
cross
argument.
Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
See, I'm going to use Ms. Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
All right, I'm gonna let you guys duke it out before I get into the golden rule stuff.
All right, do we have that? There is something going on. Wait, did I just mess this up again?
Something's
know.
going on in the background. I don't know from whom.
To me, everyone says my mic is loud.
Wait, why is this not on there though? Oh, because I did that. I'm not hearing anything in the background right now. I've got my mic on. You've got your mic on.
Yep.
Yeah, my mic is on.
Then I think it's the stream. I think this is a stream because they're now picking up because they had to mic the other courtroom, and I think they're picking up feedback.
Okay.
I don't know. See, I'm going to use.
Let's mute them in the meantime.
What is
All right.
going?
Go ahead. I just.
Say a word. Oh, and go ahead and put yourself on mute now.
To everyone asking, the golden rule issue comes from a case which basically said that it is not legally appropriate to invoke do unto others as you would have done unto yourself as a sentencing measure. They're getting really goddamn close to that, and it's ticking me off. That's where I'm at, and anyone can comment however they'd like, and we can move to another topic.
Yeah, I guess, and whether or not it's permissible in argument as well, has gone around. But that can get technical.
It can, but it doesn't need to. It's a fairly simple concept.
Why, yes, we do. Why, yes, we do.
All right. So, do you think he actually advanced any arguments
There.
in his?
We're going to draw a
morning-
distinction
his
between
early
sentencing
afternoon?
and decorum. Okay, perhaps.
Does anyone think he actually advanced any arguments in this early afternoon, or do you think he just made an ass of himself?
Oh, he's got no arguments.
I gave him one. If he watches Law Talk with Mike, he might actually have a legal argument.
I think he would probably not like Law Talk with Mike and the general channel reaction to him.
I don't agree with him, but I at least play devil's advocate every now and again. I got nothing from that last hour. Or half an hour. Jeez.
I've got nothing from the whole trial other than this guy's, insufferable.
He hasn't done him any favors at all.
I'm interested in whether or not he, who else is he going to call? You're saying he's got mom set up for Monday via subpoena?
That was what he set forward in this morning's preliminary.
I think that's ultimately his goal, is to drag this trial into next week so he has another 3 or 4 days of attention. I think that's ultimately all he's shooting for.
Yeah, that could be the case. Which is sad because, again, I've said this multiple times over the last couple days. There are 6 people dead, including an 8-year-old child.
Mm-hmm.
Let's never forget sight of that. And I am sure that the prosecution will bring that back in their closing after all of this nonsense.
Oh, yeah.
How about that? Is my mic better now?
No, it's not.
Sounds good to me.
Oh, it sounds totally warped to
Right,
me.
so we are
But
back on the record. I've been advised that Mr. Brooks does not want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom. It is my sincere hope that you want to come back here.
Oh, good Lord.
I
Just
see
make the
you're
record. He
reading
chose not to.
something,
Let's carry on.
But we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. I'm going to ask you if you are ready to answer my questions from previously and also to let me know whether you are asking to stay in that courtroom.
no.
I've been advised, you can hear and see. Mr. Brooks, we are on the record.
Oh, dear.
I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
No, he's sitting there pretending to read a Bible.
The audio is on. Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true?
Oh, shut up. He's going to freaking spend our time and the jury's time replugging in his stupid headphones.
Record to reflect, he's putting on the headphones.
He responded to a question. He hears her.
What's going on?
Fuck you. I'm sorry.
Mr. Brooks, I'm inviting you
Yeah.
back to the courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't.
Nobody held you in contempt.
Then why am I even over here?
So that
I
I could
did.
make a
Because you
ruling
couldn't
and make a
control
record
yourself.
without an interruption pursuant to my authority in Illinois versus
I'm
Illinois.
having a cigarette.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
No.
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
That's up to you.
Sir, I
I
need
don't
to
wanna
continue with the trial.
Is that
I don't
So
wanna
if
keep
you
you
don't
held in
answer yes or
contempt.
no, then I will presume you want to be in that courtroom and you'll, by your conduct, waive your right to be in this courtroom.
By what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't want to be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
Care what you
I'm
want.
supposed to be in there anyway.
I'm chain smoking another.
So twice now I've asked him. He has not answered a yes or
I've
no.
been trying.
Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
Perfect clip. God almighty.
Just, yeah, that's all day, just wasting time. She won't do it though, and he knows it. She won't take any further action. I get it. I get why she doesn't want to.
I think that he believes that if he's held in contempt, it can cause a mistrial. He's wrong, but I think that's what he's shooting for.
I just say call your next witness. If he doesn't do it within say 2-3 minutes, then say okay, you don't have any more witnesses now. Do you want to give a closing statement?
All right, everyone asking me to breathe, relax. Like I can be frustrated without having a freaking aneurysm, although I'm getting close.
It's I mean, a mistrial doesn't do anything for him anyway, other than get another trial, which he'll also lose. A little more attention, I guess.
He's a narcissist. He likes the fact that this is televised.
Well,
I haven't smoked weed in almost 10 years, and I don't intend to start now. I'll stick with nicotine.
yeah. Any way you slice it, he's not getting out of prison.
No, he's done. He's totally
I mean,
done.
even if you got a mistrial, they're not going to let him out. He's gonna sit in
He's
jail
already
waiting for the next
custody.
trial.
It's not like they're giving him any sort of bail ever for anything.
Right. So I think she's a little, you know, I at this point there has to be a default option. If he doesn't participate, he can't win by not participating. That you can't allow that as a matter of law.
We're getting extremely close to that point. And I think that she's trying out of abundance of caution to make sure
I get it.
to
You
cross
credit
her
record, you
T's
give
and
him
dot her
several
I's.
chances, but there has to be a point where it's over.
There has to be. Otherwise, the system can't work.
Yep. Otherwise, that would just be the tactic of everyone. Just
It's a heckler's veto on your own freaking case.
Yep.
Oh god.
What did we do to Ben? Did the lady scare him off?
I don't know. Ben kind of floats in and out every now and again.
Ah.
But no, at this stage of the game, like, what more evidence do you need to be comfortable if you're a trial judge? And I'm genuinely asking this question. If you're a trial judge, what more do you need in a record to make this borderline appeal proof?
I don't know. That's another thing. Yeah, I never have been a judge, so I don't really know what they're dealing with.
Well, I know I've done some amount of appellate work. I know that this is not a record that I would like to try and submit in an appellate brief.
I agree with not holding him in contempt. It's a waste of everyone's time and plays right into his hands. But so the sanction for not cooperating for me is you're waiving things. That's
Right.
got to be it.
I think he's getting very close to waiving his ability to call witnesses anymore.
Yep.
I think that would be the appropriate sanction. I don't know Wisconsin law. Do not take that as legal advice, but I think he's getting very close to that being an appropriate sanction.
Yeah, and I might just put him in the other room where you can mute him and say, "Fine, state, give your closing argument." Then ask him if he wants to give a response, to give a closing argument on his own behalf. He won't cooperate with that either. And then
That's the
give it to
rush
the
to
jury.
judgment.
Yeah, it's a rush to judgment.
You know what? Honestly, a rush to judgment at this point is kind of appropriate, given his behavior.
He's
I'm pretty sure that the jury is pretty much made up their minds.
yes, but the phrase "rush to judgment," assumes that you have these preconceived notions, right?
I know that
This is a judgment after piles of appropriate evidence. That's called a judgment.
I don't think that there's a single witness that he's going to call that is going to derail the state's case. I just don't see it. He doesn't know how to do it.
Well, there's nothing you can do that would just overturn all. That video of him doing it. That's it. He effectively confesses to the investigators and in his opening statement.
All right, let's take up the issue.
Not quite,
of
but close.
The letter and the photographs and your offer
Yeah.
of proof, sir.
That
You can
opening
have
statement was awful for him because he basically
Oh, that's
confessed to
fine. Do you have an
basic
offer of
facts.
proof?
Past all that. We go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Now the jacket's
So
gone.
I'm going to ask you for a third time. Do you have an offer of proof
I
related
just said
to
no.
the rel-
I just said no. I just said that.
Good.
All right, thank you. Then
Okay.
based on there being no offer of proof, then my decision stands.
Oops, I didn't mean to do that.
Examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
What topics generally were you going to question her about?
He has no idea.
I guess I would have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination,
I
or
don't-
already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to prevent relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already covered.
I've caught a
What,
lady.
pursuant to the police report or something? Is that what you're asking? I don't
I'm
understand.
asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you said related to topics, right?
You can just give me the topics. I think that's fair.
Oh my God.
I wanted to ask
I
questions
told you
about
he
the
went
police
from
report.
O through S. He didn't get to T, so he doesn't know
That
what the
was
definition
the last
of
few
topic
questions. That's why I'm saying it was only.
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here. Possibly is.
Do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett, with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
This screen.
What about the police report, sir? Do you want to question her about, so I know with
I'm
specificity?
frustrated, but I deal with this.
Oh, I'm looking at it now.
There's every now and again that when I was working at a law firm, I would go out to the parking lot and just scream into the ether.
How many officers did reports? Because it seemed like it's more than just 2. At least from this paperwork, is more than 2.
May I have Bill show me what?
Mr. Brooks is referring to? I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. I have to snatch it.
So I've got,
Pages 2 and 3 out of 6 from Detective Barrett's report under Waukesha Police Department incident number 21-047533. This is one of the 2 reports we've been talking about regarding the statements that Ms. Patterson
Hey,
gave.
if I can channel that for you,
November 21st,
happy to do it.
and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the question.
Under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just
Hallelujah.
about close.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning.
Good
and you
for the
failed to
judge.
testify for this court.
Thank you
and
for
told her
finally
you
stepping
wanted to
in.
make- She would testify to about what's in that report.
How do I, first of all, the report isn't even in order. So I would have to essentially read at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out. The jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the
Which
witness?
they
out?
won't.
You have to do that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under
Oh,
Illinois
dear
versus
God.
Hammock. It's a warning that you will forfeit your
So I
right
might
to
as
be
well just have just
No
stayed over
such
there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
going to get held in
Brooks,
contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're going to
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're
You're attempting to hold me in contempt. That's what that is.
No, that's not contempt.
So it's a civil
Ooh.
or criminal.
Take me to the other courtroom. Do it.
Why am I being held in
Just
contempt?
go with it.
He's gonna blow.
I'm
That's
going to
the-
keep
that's
you
the
in
whole-
here because
that's the
there's-
whole
you're
reason
gonna
I
need
didn't
to
wanna
call
come.
the next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me.
I don't
Contempt
wanna
is
do
a
it, sir.
criminal
I'm
Obviously
sorry.
you do.
Remove me from
Obviously
the
you do. You
courtroom.
brought it up before we could even get to.
All right, Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though
did
it will be
Please
I
short,
say this
forfeit
trial.
that right?
you have forfeited your right to be present.
And how did I forfeit that right, Your Honor?
All right, we're going off the record so that he can be removed to the other courtroom, and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in
You're
contempt.
Then what did I do?
All right, I'm going to step off. You've interrupted repeatedly. I'm going to step off.
Oh, dear God.
Unbelievable. But she did it. He waived the witness. And if he keeps going, she's just gonna keep doing that again and again until he's done and we're through the witness list.
But I don't think that I don't think she did waive the witness.
No, she said the testimony is closed for this witness. You can't question him. That was her finding.
Is that what she said? I thought that she said that he could question from the other courtroom.
No, she said they're going to bring the
Unless I
witness
missed
back in,
something.
but I'm closing testimony for the witness because you don't have an offer of proof for what you want to get into, which is the right
All right,
ruling.
so direct is done, but the state still has right to cross.
There's still, the state's still going to cross-examine.
Which honestly, I don't think the state has any cross.
There's nothing to cross. I mean, you can do stuff. They could get more information if they felt like it, but I wouldn't. I would just get you.
They
winning. Just
already
get to the
called
end.
her.
Yeah,
So what more questions do they have to ask?
they have what they need from her
So
and from everybody else.
I think I would just waive cross at this point, and the point was made.
Mhm.
Honestly, I would prefer to waive cross in front of the jury. It would look magnanimous after this asshole. Sorry, I keep cursing, but it's really tough for me to deal with this guy.
Holy shnikes. Do I have to slow the chat again? Yeah, I'm with you, Nigel.
Yeah.
I think that's where we came to.
I think Nigel's absolutely right. I wouldn't cross. What's there to cross over? He didn't ask anything that's actually reasonable or relevant.
The state's got this. He's not making any points. You're looking to get to the end.
Yeah, at this point,
you're looking to get this thing to the jury at this point. You've got a winner. You know you can show the video and appropriately pull on emotions for a close. Let's get there. If you're state.
Well, and that's the thing is, I think he's genuinely, what is it, 1 o'clock right now in Waukesha? I think he's trying to bleed this into Monday.
Mm-hmm.
And I don't think the state cares.
They don't. Nobody wants to do that, but like this is a big deal case. Like the state isn't scared that this gets held over to Monday. It doesn't hurt them in any way.
I think he wants to bleed it over to Monday.
Well, yeah.
I don't think the state cares one way or the other.
His best hope, I hate to say, and she made it clear to him, his best hope is that someone else gets COVID and they can't complete it because they don't have enough jurors.
Yeah, but my understanding, and we talked about this yesterday, what we heard from the chat, and I was able to confirm, was they picked 16 jurors. They only need 12. So they lost 2. They're down to 14.
That's getting close.
It's not great, but do you think every single one of those jurors said that they were not worried about COVID? So that's not a great sign for you when you're the defendant and your entire jury says, no, we're going to sit here regardless of risk to our health because we want to finish this case. I would suggest that implies an opinion that they might have formed. Yeah.
Slow down the chat. Aw. You're being sweet. Oh, thank you very much. It happened a little bit earlier, but I learned that from you guys. I didn't know that.
Yeah, congratulations.
Yeah, thank you everybody for it's really the chat that's doing this.
So how many more witnesses?
My role here is basically to make a thumbnail and find the stream. And even that I dropped earlier.
Yeah, I'm terrible at both of those things.
Okay, let me go over there. Holy Toledo. Yeah.
I'm almost at 2,000 subs, so that's cool.
That is amazing because you just started.
Yeah, about a week.
Ben could just take off tomorrow too because now everybody knows you. You've been on here.
Yes.
You can just instantly start a YouTube channel. It's awesome.
You make it sound so easy.
It's
well, the judge did.
Go ahead.
Did close him down right there.
So, do we know how many more witnesses he intends on calling?
Yeah. This is the 4th, so he has, I believe, 8 more.
Oh my goodness.
So so if he's back out there, can he question witnesses from there? I mean, does he have a mic? That's all you need.
Somebody said 6 more, so maybe I'm wrong. I thought he had 13 originally, and one of them was the state of Wisconsin, but I could be wrong.
Oh, yes. I'm sure he's calling the state of Wisconsin.
Yeah, he has a mic, but he can be muted if he's in the other courtroom. If he starts acting out. So I don't
Okay.
see why it would be a Sixth Amendment violation to let him question witnesses from the other courtroom.
Wow. So, Mike, are you 70,000 now? Is it official?
Yeah.
Wow. Big
Thank
time.
you.
I remember doing a shout out for you when you hit 30.
Yeah, we did a whole special. I think it was who was on that? You probably Deborah. I don't know. Yeah. Oh, yeah. You did a shout out for me from Vegas, which was awesome.
I wasn't
Yeah, from the
invited.
Welcome to Vegas sign.
I didn't know you, John.
Hi, Shaughnessy.
I'm kidding.
That that was Dep v. Heard.
That was a long time ago. That was way before I actually got involved.
Dep v. Heard is yeah. Oh, you guys are so sweet. There you go. You got one more.
Thank you, Kathy.
That was his first witness attempt. State of Wisconsin, and was rejected soundly.
Because he didn't name a human being. You can't subpoena an
A
entity.
bummer. I'll be right back. I have actual law work to do.
Clerk, would you please have the jury brought out and make sure all the monitors are on?
I guess we're back.
You are unmuted, sir. The jury is on its way in. Well, will be shortly.
We're gonna have some more fake Bible reading coming on here.
I'm going to
Probably.
mute you if you do that, sir.
I'm not
That was
gonna
the
go
easy
in the jury.
question
That's why
from the other
I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record? Will I at least be told why I'm held in contempt when I didn't do that? Civil or criminal?
That's a misstatement of what I did, sir.
So why am I
I will
over?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted.
Jay Rabine.
You gonna mute me anyway?
Oh, I got to put a link to that. I'll do it right now.
Seeger's been
So I
doing
gotta be
it.
quiet like a little kid?
It's not what I said, sir. You have to be respectful. You have to be respectful of the proceedings.
But nobody has to be
That was
respectful of me though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen them through the TV screen and made me feel uncomfortable?
Jury's coming in. Please rise for the jury.
I mean, you can say it, but we don't care.
Be addressed.
Mr. Brooks, I'm
Yeah,
leaving
nobody
you.
cares about your opinion.
Yeah.
Thank you, Sharon, by the way.
Okay.
Lots of people across the country are making gestures at you right now as we speak.
Thank you, Nanner.
Okay.
I have some very strong opinions on the subject.
John's channel is linked in the description.
Can I have the preliminary instructions for a second? You should just keep them. They're nearby. Thank
And
you,
if you
everyone.
actually
Please
get
be
through
Oh,
seated.
that's sweet.
No.
She must like gingers.
Jesus Christ. God damn. We're doing
For the
so
record,
well.
Mr. Brooks
If
is
it keeps
appearing from
giving.
another courtroom that should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness? All right, thank you, ma'am. You may step down. Thank you for being here.
And by the way, shameless plug, if you do happen
All
to
right, the defense
stick
may
with
call
the
its next
trial,
witness, please.
we might flip over to my channel and I'll run a stream on just a couple things, maybe half an hour or so. One's a fantastic lawyer letter, and the other is one of my favorite cases on client loyalty.
Go ahead,
So-
sir. You can call your next witness.
I thought I was muted.
You're not muted.
So how long am I
Come
supposed
on,
to
Mike.
stay
You
here
said
now?
you'd plug this if I did it.
I'm going to excuse the jury. We'll hopefully have you back shortly.
Well, I don't know when it
Testify for
is.
the jury, please.
I mean, I'm all for it. Everybody go watch when it happens.
I'm just gonna run it. I'm just gonna run it like half an hour after you close your stream.
Cool.
I want to keep your folks. I
I'm
already
in.
sent you one of the topics.
That will be fun.
Honestly, I might just run it straight
Right,
after
the jury
they
is
decide to
no
close
longer
for the day.
in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
Oh my God.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus Allen, Mr. Brooks was not held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address a defendant that is being discourteous,
That was funny.
disrespectful,
Okay, that's funny.
and disruptive. So
It-
pursuant
it's
to the
dark,
authority
but
in
it's
Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to
That's
some
what he thinks
persuasive
in his
authority
little
from other
brain.
jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P. 3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P. 3rd 1204. That's from 2020. And then I'd remind the parties of the district court
clerk.
decision that was later affirmed
Everybody,
from
you've gotta be working
Pennsylvania,
so
U.S.
damn
versus
hard.
Jennings, 855 F.
The answer
Sup.
is stupid.
1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those
Thank you, Taylor.
case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
Oh,
so why was
good
I removed in the
God.
first place then?
No,
I've
don't
made
let
my
him back.
findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
Mr. Brooks is not answering my question directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for
Brooks?
me. You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I
Oh,
will.
look who's here.
He's
Hello.
interrupting me once
Hello.
again. from
Okay,
the
you
other
talking.
courtroom.
You the one talking right
Th-
now, so don't do that.
This is going to make you crazy.
Because he's not being
Yeah.
respectful.
I've been
I did warn
Shouting
you.
over.
I did warn you.
So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings.
It's a pleasure to have you
I'll give
here.
him
on this
one more
discussion
opportunity.
madness.
So that it's
Glad to be here.
abundantly clear on this record that I am
Also.
honoring his right to be present, and I will unmute him.
Just saying.
Sir, would you like to come back into
Love
this
it.
courtroom as you call your
No.
next witness?
Don't try to seem like you.
I told her cocktails were required.
Okay, he is, again, not
Don't-
answering
don't-
the question
don't
Don't try to
directly.
put on no. Don't.
I'm going to mute him again, as I've noted before.
I'm headed there
this is a
soon.
Clear method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute,
Should I show up up there?
to advise you, I will ask you
Do it.
to call your next witness.
I showed up for the Summers trial.
And if I don't get a direct response,
Yeah, but I don't think they'll let me in.
Ask it again.
Why
And if
not?
you fail to give me a direct response, then you will forfeit your right to call any other witnesses.
They don't like us Chicago people
I'm
up
going to
there in
unmute
Wisconsin.
you. Actually, I need to bring the jury
Just
back
put on an
out.
accent. You'll be fine.
But before I do that, I will unmute you first and ask you which witness you intend to call, so we can at least have that person ready to go.
Stealth cheesehead,
and
I
outside
like
the
it.
courtroom. Who will be your next witness?
I'm not calling no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a record
answer
of that,
everything.
sir.
I have to answer everything though.
I would love you to
Everything
be in the
ask me,
auxiliary
you expect me
courtroom
to answer, but
and
then
just
when
sitting
I ask
behind
you,
him right there.
you never have to answer anything. I just put on the record that 2 of your bailiffs just made gestures when I'm looking at them off the reflection of the screen. They're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Are they court
Mr.
jesters?
Brooks, I didn't address it because frankly, you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time. Would you like to come back over to this courtroom?
Stop asking. This is 7 times now.
That's not answering my question, sir.
Just say yes.
You haven't answered my question.
The court's not going to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not
Brooks.
a delay and disruptive tactic. Is that a judicial determination
Yes.
that you're making?
I'm going to
At this
mute
point,
you
you know,
because
it's
we're
screwed.
going
It's
off on
not
the
actually,
judicial
but
determinations.
just say
Every
yes.
decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you
We
are
have a
convicted.
lady in the room, so I
But
can't.
we
curse
don't need to
anymore.
have this back and forth
I
every
gotta-
time to further
I
make
gotta
the
mute
record
myself
when
a
the
little
record
bit.
Oh,
speaks for
please.
itself.
Like I've never heard a
We're
curse
given
word
plenty of
before.
opportunities
Or
throughout
you
this trial to
sound
make
like that.
offers of proof,
Hey, you're a
to
lawyer.
state your legal
Fair enough.
reasoning for either
Correct.
objection or for a question that's being asked or for a whole host of other things.
You
But
haven't
right
seen
now,
a
you're
couple
not
of my
doing any
outbursts.
legally relevant. You're being disruptive. I would like you to be present. That is always
Why?
what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct.
He has
which you've done
multiple
repeatedly throughout
times.
this case.
He has forfeited his right
I will
over and
advise
over
you
through his disruptive behavior.
that if you are
and
in
it's
that courtroom,
absolutely appropriate and
because I have
reasonable
put you there
and
and you have not
upholdable
reclaimed
to
the right to be
forfeit
present
his right to
by number
continue
one
to question
asking
witnesses.
and then expressing a willingness to conduct yourself
losing it a little bit
consistently with
this guy.
decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain
Really,
over
that's-
there.
That's what I've been going through the last 3 days. It's been
And
a
it looks like he
cathartic
took his
experience.
headphones off, so I would. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses.
Damn straight. Now we're talking.
And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
It's right in there. It's the same ballpark.
Yeah, that's a good question.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones. You
Yeah,
choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And
You
you
don't
are
gotta
not.
be clear or nothing. I don't gotta listen to you.
You're not
I will
peers.
ask
You're
you
not
one last time,
equals.
sir. Who
Let's
is your
move
next
to closing
witness?
arguments. We can be done today.
First of all, is she talking?
Deliberation will be done by probably 8 o'clock, and then
Contempt.
you
She's
can
got a
go
hold of
to
him.
the rest of your
Contempt.
life.
I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
The record should
Judicial misconduct.
reflect that Mr. Brooks
Repeatedly.
is spouting off, making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking
she
the
might be going
integrity
there.
of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right
Said
to
Said
present
that
any
half a dozen
additional
times.
Show me
witnesses,
where that's law.
because you
Show
are
me where
not
that's law.
cooperating with
If you
this
don't
process.
Show me
enforce
that
it.
it's law. That's all I'm asking. Show me that it's lawful law.
Mr.
Natalie
Brooks,
might give me the handshake
How can I
too.
forfeit not being able to have a defense? Are you kidding me?
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I will
Okay.
gladly bring
You're
you
done.
back
You're out
into
of-
this
you're out of-
courtroom
you're out of
so you can
chances.
present your additional witnesses.
You're
But you need to ask me to come back into this courtroom.
With all due
Oh
respect,
God Almighty!
No, stop.
Oh dear. Let him cross-examine from the other room.
forfeit you every day. It's not my intention to come in here and have these interactions with you every day. It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive,
Bang.
because that's not the
Sorry, did I
case.
break your concentration?
And I
We're
feel
talking
very,
about didn't
very,
consent.
very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is it is your courtroom. That's not it. It's not a dispute. It's not up for debate.
Clearly,
Control
it
what's
is.
going on in there. It's not a dispute.
And you're
But the way
small
I'm
mind.
interpreting what you're doing is that I'm being held in contempt. That's how I'm interpreting. Because one of the three things that's cited in the Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt.
What's the third, Mr. Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's
I
the
muted
third,
all
right?
mics.
And
It's still doing
that's
it.
what's been done.
Okay. So now, where does it say after
Yeah,
that?
if you said it's local
That
with law and crime.
having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal. You
This
can
is
raise
why I
that
say that.
issue on appeal
This
if you are
is why I say
convicted.
that. This is why I say that though, because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the prosecution table. I can't see anything else.
I understand that, sir. I'm fully aware of that.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right to be able to see and hear everything that's
They
going
have
on?
cameras in both courtrooms, and they're overlapping.
If you can
each other.
conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law.
You're forgiven, Sparkling Dragon.
I will ask you again, would you like to come back into this courtroom?
Oh,
Are you going to kick me out? Are you going to kick me out?
Sir,
sweet
I'm
Jesus.
asking the questions right now.
No,
That's up to you.
Would you
that
like to
option.
come back into this courtroom?
Stop.
Yes or no?
This is just
Stop
a
indulging this
Sir, it's
freaking
a yes or no
narcissistic lunatic.
question. Would you like to come
Well,
back
my
into this?
answer-
Murderous
My answer
narcissistic
was
lunatic.
based on the reason why I'm answering like that.
I need to start
The
drinking.
moment I say something, it's going to get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth. It makes essentially it wastes time, really.
And do you have any idea how many
It wastes his time.
cigarettes I
Well
went
aware
through
of
over
that,
the
sir.
course of this case?
That it delays the
Yeah,
proceedings.
Yeah, but then it's laid at my feet as if that's my attempt. You think I want to be
Only
over here?
Pepperidge Farm in chat
Sir,
knows.
I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. And nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements
There
of
is no
courtesy and
conduct,
decorum
Your
so
Honor.
that you don't run the risk of forfeiting your right to be present. But
He's
that falls on
fundamentally
you and
incapable
you
of
alone,
doing
sir.
that. When are you going to get the message, Judge?
I don't understand what you mean by that. I really don't.
Right. See, I'm going to use Miss Fowler's words. She now is in a
No,
Accurate.
No.
I think you know exactly what you're doing.
If that's what you think, that's fine. I can't argue
And
with
you have
about your
demonstrated
opinion.
throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an
I'm
opening
sure he's
statement.
at like a
You
4%
communicate with witnesses.
success rate on his objection. But
So
okay.
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and understand
It's not
English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented? Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own. And you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself. And that comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair to state, Your Honor, because.
So I'm going to do the following, since I'm not really getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over. And he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer. And after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But
This is
we
what we
are
need to do.
going to continue. So
That's
we'll go off the
yeah.
record.
She
and
finally
back
she
over here.
finally
Thank you,
reached
VR.
her
Release
limit.
What we need right here. Here's how you handle the situation.
Say a word. Oh, and go ahead and put yourself on mute now.
That's Charlotte Rubel. I used to work for him
That's how
here.
it's done right there.
No, this is a judge that finally reached her limit, and we saw it coming, but she finally got there.
Took a while.
And she gave him so many chances over the course of the last several days, but she's finally reached the end of her rope, and she's like, "Look, you're either going to participate or you won't, and then we're done."
Well, I think she's
was
in a
losing my
difficult
mind.
position too, though. I mean, she's dealing with a pro se party. She's trying to give him the benefit of the doubt. She's doing the best she can without just completely letting all of the proceedings go to shit. So, I mean, I think she's doing a good job. It's annoying to us having to watch it, but I feel like she's got a little bit of her hands tied.
Lily, you're absolutely 100% right. I agree with you. You haven't been here for the last 2 days.
No, I have not.
She's given him every opportunity on earth to try and actually participate in his own defense.
Yeah.
And he refuses to constantly.
What I want to know is the big issue. Was there a poodle sighting earlier? I'm seeing it all over in the chat. I'm like, I've seen the poodle. We had a little chat, and I saw the poodle. Only because you're kicking the sweet thing out so we could talk.
She
Let's
is
see.
a standard poodle. She is.
We're
my
dog
baby.
lovers here. Oh.
She's a big gee. So
It's a big dog. And a sweet.
Is that a golden doodle?
Oh no, she is a standard poodle.
Oh, she is. Oh God, that's beautiful.
Everyone asks me that. They're like, "Love the doodle."
Nice.
Poodle.
not a doodle.
Not a
Definitely a
doodle.
poodle. All right. So is this thing happening then? Well, all right. Predictions. We'll go around here. Predictions. Does he come back in?
Yeah.
Because I'll tell you, if I was sitting, I think he's going to come back in, and we're going to have another hour of this same thing.
Yeah, I think he's going to come back in and act a fool, but it'll be in front of the jury, I guess.
I agree with Lily.
I agree with what the judge has done.
Yeah, he's coming back
for a while, but at this point now, if I'm sitting on the bench, I'd say, okay, I've seen enough. You forfeited your right. We'd be doing state's opening statement right now.
Closing.
Yeah. Because you got like 3 hours of that stuff. I'm like, I can get that in today. We'll get to the jury. They'll take it home for the weekend, come back, tell us he's guilty, and we're all done.
This is obnoxiously disrespectful to the jury.
Yeah.
That's who
Forget
gets
the
it the
court.
worst.
I mean,
Forget the judge. This is obnoxiously disrespectful to the jury's time.
Mm-hmm. Yeah.
and he's got nothing though. What's he? I mean, this is all he's got now. I mean, he doesn't have witnesses that are going to help him, or if they could, he wouldn't know how to examine them to help him. So what's he got now? Just try and blow this up.
So Ben, you weren't here this morning. You weren't here this morning. He wants to subpoena his mother on Monday. His own mother. It's like, why? For what purpose does that actually serve your case? I don't know. He doesn't know. It's all delay tactics. And at some point, it really is disrespectful to the jury's time.
I told you last time I was on here, this judge reminds me of Judge Levitt, who I'm fond of. But it took her forever to revoke Mr. Blandino's right to self-representation, for instance. I mean, she ultimately got there, but it's a long, long fuse.
Yeah, because you don't want to pull that trigger because Sixth Amendment, you don't want to get reversed. Mm-hmm. I understand that. But at some point, if you are blatantly disrupting court proceedings as a delay tactic for I don't know what, you gotta be able to close that chain and just be done with it.
See, I think I think she's justified now. I mean, if whatever she decides, she does not allow him to continue. I think she's made her record. I think.
Yeah. And you were here. Like you saw her.
I mean, I don't think it would get reversed on appeal.
Yeah, you saw her. Like she was very meticulous in building the record of all of the disruptions.
They're both pretty cute.
Oh.
But you saw her build a record of all of the disruptions, and I don't think that this is an appealable matter. I don't know what the appealable matter would be. at this point, I don't think any appeals court would take this up anyway.
No, that's
Well-
just, I think she's been patient enough that and endured enough that I think if she decides to send him sideways, kick him out, not let him examine it, not call any more witnesses, make him go straight to closing, I think she's there, in my opinion.
I don't disagree, but I'm not in criminal law. So, Lily, that might be your field of expertise.
I'm not criminal.
Okay, well.
Natalie's trying to come in. Which Natalie? Natalie Lawyer Chick or Natalie Wisco? I've had. Oh, there's a lot of moving parts here.
It would be great to have.
Oh, Natalie Lawyer Chick. I sent her a thing earlier. Oh, there. Oh.
Hello.
Hi, Natalie.
I'm like, hi, let me in.
Natalie, I don't know if you know Ben and Lily.
No,
I'm using my cursor like everyone else can see.
Hi, Natalie.
Nice to meet you all.
Nice to meet you. Good to have another woman.
Yes.
Pleasure.
Well, I'm always happy to balance things out. I won't be here for long, but I saw that you were still, because when you sent me the link originally, I was still in court. I saw that you were still live, and I was like, let me come on over. I've only been able to catch things intermittently today because I've been in court, and then that's the jail calling me right now, and I've been in the jail, so it's a lot. It's like the first time I've gotten home, and from what I've seen though, it's worse than I could have ever imagined. I mean, I've seen this. I've seen clients do this. I've seen this happen. It's just I've never seen it on TV be this bad. This is bad.
So can I ask you a quick question? Not to steal Mike's thunder.
Oh,
we were just talking about is it appropriate if a defendant is self-represented and so disruptive, and I really want to get a criminal law attorney's perspective, if they're so disruptive, would it be appropriate to withdraw their right to call additional witnesses and just move on to closing arguments and be done with the case?
The judge can make a finding that Mr. Brooks has waived his right to a defense, because you can functionally do that by refusing to participate. So she can make a finding on the record. That would be more open to an attack on appeal than any other decision she's made thus far. Like, she'd be well within her rights to do it at this point, because clearly he doesn't want to participate. He doesn't want to call witnesses. He doesn't want to come to the end of the case. He thinks he can stall it out forever. But just completely removing his ability to present a defense is like the nuclear option in this whole thing. Although we're at the point where he's just made it clear he's going to consistently disrupt no matter what happens. And so she can make a finding on the record that by his behavior, he's waived his right to present a defense.
Thank you.
I've never seen that happen before, though.
I mean, that was my only question.
Right. I've never seen that happen, but I know that it can. And I know the judge would be very hesitant to do that, but it seems like that's where this is going. It doesn't seem like she's going to declare a mistrial and appoint him counsel, because she can't appoint him counsel now and have that person just step in and take over. No one's going to be caught up to date. The public defender will not appear as standby counsel. That's in their statute. In the state of Wisconsin. So they will not appear as standby. So someone has to be retained to go into the case, and they would have to catch up on a 6-time murder trial. There'll be no way an attorney can catch up on that. And so it would have to be a mistrial, and she doesn't want to declare a mistrial,
No, certainly not.
So it's either declare a mistrial, appoint him counsel, conduct the next trial without him being in the courtroom if he won't behave himself, or say that he's waived his right to present a defense or call any further witnesses.
Yeah, I mean, the problem is you can't gag them. You can't just put them in and proceed without. Well, you can make that finding, but then that's effectively waiving his witnesses, since he doesn't have an attorney, and that's it.
That's what I'm saying, because if she gags him, he can't present a defense.
Right.
And that would be more prejudicial to have him sitting in the courtroom gagged. So it would just be better to just say, remove him from the courtroom, put him in the room with everything turned off, and tell the state they can start presenting their rebuttal case, and given the opportunity with each witness to cross-examine those witnesses, give them an opportunity to a closing argument, and then say that he's waived those things over time if he refuses to participate. But I think that that's really the only option she has now, because it's been hours, and every time I tune in, I've been trying to watch it live. Every time I tune in, he's been disrupting. So it's very clear he doesn't want to proceed. And a ginger?
Poor John. He's just...
And apparently he's yours truly. Although I'm blonde.
But by mistake, they weren't actually referring to him. Somebody in the chat referred to him as Ginger. He got all defensive, and now the chat just won't let it go. I mean, 3 days of it.
You're a ginger.
It is funny.
Okay. Okay.
Oh.
I actually have so somebody asked a question, and I believe I know the answer, but we have a good panel. If he's convicted, he doesn't have a right to counsel on his appeal.
Yes, he does.
Does he?
Yes.
Well, yeah.
Part of the criminal proceeding, you have the right to counsel.
Huh.
Yeah.
Okay.
He gets.
But can he represent himself on appeal in Wisconsin?
Say it again.
Can he represent himself on appeal in Wisconsin? Because here in Nevada,
that's what my question is. That because he's already waived his Sixth Amendment rights to appointed counsel in the trial court, does he then get to re-retain them on the appeal?
You know, I didn't think about this.
Ben, were you Michael McDonald's attorney?
No.
Why
Kim
do I
Blandino.
recognize reflect that Mr. Brooks is present in the courtroom in person? Wearing a suit and tie.
Oh, yes,
Actually,
celebrity.
his suit coat is off.
All right, we got to go back. But we've got attorneys from Illinois, Florida, also license New York, Georgia, Maryland, Nevada. Boom.
Yeah, we got 5 states right here represented. 6 states.
Before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
Oh, he's back in the courtroom.
The record
Last
stands.
time I looked, he was out.
You right now have lawyers representing or licensed in 6 states right on your screen.
I make no such agreements with you, sir.
So that means you can answer a question then.
If that isn't an invoice of lawyers, I don't know what
Will
is.
it be addressing subject matter jurisdiction on the record? And will it
I'm
be
getting my
verified
cocktail.
and proven?
I can't take it.
He just won't stop. It's very
I simply
disturbing.
can't take it. I thank you all for the therapy and coming along with me here.
Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
It's
Tacit agreement.
It's not tacket.
Tack it to the wall.
Oh, he won't be able to show up in front of the jury.
I saw that earlier. He just was going off in front of the jury.
It doesn't help
Thank you, everyone. Please be seated. The defense may call its next witness.
Who's here?
You should know it's your
Bertram,
witness.
Hayes,
dummy.
Aldrich, and Lescano are present and ready.
And
Your
they've
Honor.
said it
Thank
multiple times.
What was the last two?
Aldrich and Lescano.
Why would you look that stupid in front of the jury? Why wouldn't you ask that before they come into the room?
Yeah. Sorry, Ben. I was doing that thing where I was staring at your face like, where do I know this person from?
So, yeah, someone said I'm Kim Blandino famous.
There it is.
Deanna Aldridge? All right, very well.
He always walks the line and narrowly avoids the worst possible consequence. So he's going to present more witnesses.
And I apologize, Ben. I did not mean to disparage your criminal chops. It was
No
just
worries.
fun when they came in.
That would be crazy, high flyer. Not impossible. Oh, wow. His face.
Oh, we can do 5 minutes of this again.
This is what court is really like. A lot of hurry up and wait.
I'm sorry, Anna, I think she was in the other building, so.
That's all right. Thank you for letting us know.
Does anyone know who he's calling? Is it one of the victims again? Because those are just god awful.
What'd you say?
I was asking Chad because they've been following it. If they know who he's calling right now, because it might be one of the victims, and he's been doing this, and it's been just awful.
Yeah. I think he was just making stuff up, Amber.
No. Is this any better? Or do you want me to reload?
No, much
that's
better.
way better.
Okay.
Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up by riser. When you get all the way to the witness stand, please remain standing. Raise your right hand, and my clerk, Teresa, who's on my left and will be across from you, will swear you in.
Hi, Linda. No, I don't have anything to say about his tie.
For the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Come up and have a seat.
So, maybe he should take off his tie, unbutton his shirt, go for the Mike Gravlin look. That might score points with the jurors.
First thing I will ask you to do is to state your first and last names for the record and then spell each.
Deanna Aldrich, Deanna. Last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldridge. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do
You
for a
didn't
living?
start. You don't have to have anything to back up to.
That's always pretty good.
Can you state your name for the record?
Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes,
Where were you staying at the time?
I live on Maple Avenue.
And during that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
Back up a little bit to the thumping noise. Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV?
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes.
And at some point, did it cut off?
Yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far
description
as
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though. Okay. He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So no, Jerry, there's nothing federal here.
Glasses so you can get a better look at.
Well, there shouldn't be.
Observing.
Maybe
yes.
Some prosecutor can on this one.
Do you recall if the SUV had any tinted windows?
I do not recall.
All right, Mike and friends, peace out. I'll see you guys later.
See you, Natalie.
Thanks for coming by, Natalie.
Bye.
Good to meet you.
Do you recall what time of the evening you heard the the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not, because I yelled to them and said, don't touch it.
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah.
Do you recall how many people there were?
Maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
Now, for 2.5 days, I've been trying to figure out where he's going with any of his arguments, and it's just, at the very least yesterday. I was trying to figure out where he was going. He doesn't know. Nobody
If you recall,
knows.
did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
Ask her if she knows the plaintiff.
He'll get there.
Always a good time. Always a good time.
The street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
Mike, this chat is just awesome.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
But that general direction would have been, which street did you say?
Arlington.
Arlington. I apologize.
No, unfortunately, this will not set a standard. Answer one of the
Were you
folks
aware
in the
that
chat.
there was a parade going on that evening?
Yes.
Did you attend?
No.
This poor woman, she's see her hands shaking.
Yeah, she seems stressed. Understandable.
Absolutely. I just feel terrible for her.
after you spoke with the law enforcement officers that evening, did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
And this has been the case the entire time that he's brought in witnesses. They're really nice people that come across extremely well. And you feel horrible for this community.
Does he trying to get the what? That it wasn't him driving, that she couldn't identify him? Is that
Do you
where
recall
this line of
the
questioning
name
is
of the
going?
officer that-
He has 3 parallel arguments. Maybe in the mid-afternoon.
The poor thing is shaking.
I know.
she's-
I feel terrible.
She's fidgeting. I get it, but still.
Yeah.
She's so uncomfortable on that stand.
Well, she's probably never had to do anything like this. I mean,
Yeah.
it's a big case, you know, so.
And she's having to face this person that she probably knows did this awful stuff.
Yeah.
Yep. And if it's the state would have prepped her because they know what they're doing.
Yeah.
They would have brought her in, sat her down, and she'd be much calmer.
Yeah, she just got straight up subpoenaed and had to show up.
Subpoenaed by a monster. Yeah, it's a bad situation. It is. Don't worry, Lily. Ben's been getting it all day.
Well, glad I could relieve him of it.
And John's been getting abused with the ginger thing for 3 days in a row.
1 second, you're right.
It's just part of the process here.
I'm getting used to it.
Best chat on the YouTubes.
Oh yeah, getting some Lily thirst here going on. What's happening? Gotta go back to the.
Yeah, you might get some time off, Ben.
All right. Yeah, I gotta go here.
The defense calls.
The jail opens up at 12:30 for.
All right, thank you.
Oh,
Ben, you have court up?
no, we gotta go get some visits done here. Some jail visits this afternoon.
Like Natalie, yeah. Our criminal defense attorneys are spending all their time in jail. Imagine that.
Yep.
I presume the stir
That's a good thing.
that was assisting. Thank you.
Your Honor, my assistant.
I didn't want to assume.
Anyway, all right. I will check out. Hopefully, it's still going on when I get back.
All right. Thanks for coming by. You got the link.
Everyone. All right.
So, John, what do you practice?
Right now I'm in between jobs. I'm actually considering a public defender's position, but historically it was med mal and just general civil defense.
When you get there, please remain standing, raise your right hand. My clerk, Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Have a seat, please.
A little bit of workplace incidents, a little bit of med mal,
Ask
but
you to
insurance
state your
defense
first and
generally.
last names for the record.
That's right. That's what I'm talking about right there.
Last name is Bertram.
Could you spell those, please?
CHRISTOPHER BERT.
It sure was.
Thank you. As long as you sit close to that table, you will not have to lean.
Come rain or shine, the job must get done. We get you, Steve in Denver and Kay in Fresno.
Thanks,
Always
Law and
make it
Crime.
happen. And we're here for you with 24/7.
Love it,
service.
Sean.
Trying to monetize it or
Click
not.
Granger.com or just stop by. Granger, for the ones who get it done.
How do you not have ad block?
Oh, I'm sorry.
But they haven't been running ads.
Okay, your witness.
first of all, good afternoon.
Mike, you're the best, but where's Ben at?
What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2021. Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
Were you aware of a parade going on that evening?
No.
Yeah, my court audio is a little bit low. I don't know if there's anything you can do on your end.
Around what time were you taking?
Someone thought they'd get you both. That's nice. That's
recall.
nice.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And
Thank
do you
you.
recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did you see anyone driving it?
Yes.
And were you able to make a description? Sorry, description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
You made reference to giving a statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone? Or...
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
Oh, thank you.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tints?
Any what?
Tints, like tinted windows?
No.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle, or sometime after?
The same evening.
For what seems like a kid,
Do you
he's
recall stating during the
in terms of not
interview
giving any material.
that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Thank you, Cal. I'll take that.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly
Absolutely.
a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it passed you?
I do not remember.
Do you recall during your interview with law enforcement that evening stating that you thought the operator was wearing a black sweater or jacket as it drove past you?
If that is what is written.
Do you recall saying that?
No.
He'd make a great corporate rep in a civil suit. Doesn't remember anything and doesn't answer any questions.
And do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
I mean, God, this
And do you recall
kid looks
what
young now.
agency your interview was conducted by?
Yes.
And would you stay for the jury and the record?
The FBI.
Yeah, but your chat thinks I'm 16, so there's that.
It could be worse, my man.
Do you recall stating in your interview that evening with law enforcement that you heard
It's going nowhere.
a lot of gunshots?
Yes.
And do you recall I think that's a little bit unfair to say. If you had to estimate where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
No, the dogs are my fault. I'm pausing.
Do we have have we kept track of the witnesses? Like how many he might potentially has left?
Do you recall?
I think this is the fourth.
Vehicle that you observed crash into anything?
No.
I mean, we now know none of them are going to say anything that's helpful to him.
How
That's
many
clear.
has he said he has?
He subpoenaed 13, one of which was the state of Wisconsin, which got tossed. So 12 total. I think we're on our fourth. Maybe somebody.
Recall
fifth.
stating,
All right, somebody in
They
chat.
took one out of order too.
And they took one out of order.
appeared
So
to slow
maybe, yeah, there's 6
while
left.
traveling down Prospect Court.
Yes.
Plus he subpoenaed his mother. Yeah, that's true.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called 911?
No.
So I'm going to say it again. If you have to subpoena your own mother.
Do you recall shortly after?
Not a good
Ben
place.
and Lily don't have channels yet, but don't worry. They will soon.
Texting anyone?
Mike will peer pressure you into it.
Oh, yeah.
That was?
Oh, I'm relentless.
I'm a victim
I've
of that.
started getting it a little bit.
Yeah, I've started on both of them.
Do you recall telling her there's a shooting?
It worked with John.
So far, not so bad. Almost,
Thinking about it.
almost 2,000 subscribers in like a week and a half.
I
Oh,
beg your
really?
pardon. I was a math major at the University of Michigan.
Yeah, I'm at 1974. So anyone who wants to subscribe who isn't, please join me.
I hear a cute puppy somewhere.
But you do recall.
Yeah, they're good boys.
The operator wearing a
They
black
stay out in the backyard.
I don't remember.
I might have to go squeeze Oscar.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Thanks, Bean John. You're the best.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that?
That's a
person
good question.
I don't remember.
Grounds.
This answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir.
I think because they do it in short form, it's probably gonna ultimately in the transcript show up as proper English, but I don't necessarily know.
All right, go ahead. Call your next witness.
I'd subscribe
Thank
to your
you.
channel, Lily.
Thank you.
Break. I have.
You got one right there.
There we go. Got to start somewhere.
You can make an account for the poodle. There's two.
After your next witness.
There we go.
All right. I'll address a legal issue, and we'll bring the jury back in when we're ready. All right.
That served absolutely no purpose whatsoever.
That's all. He just does. He goes nowhere.
That was an abject waste of time. So everyone complaining that I'm talking over him, go watch the stupid nonsense. Our conversation is more interesting than anything that he's asking this kid, and the whole reason is just to drag this kid into court.
Everyone can have a seat, and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I'm curious.
All right, one more. I'm at 1999. Who wants to be the 2,000
Just by the
subscriber?
reports. How's
Get over to Jay Rabine and subscribe.
how are some of these answers
We got to blow by two. We got to blow by two.
pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is,
Yeah, you think?
reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it. Don't have any cross-examination.
Yeah.
Mainly because you've already schooled the people getting on the stand on how to answer certain things.
Yeah, because they've already proved the case. Bingo.
Genius.
So
They don't want to waste any more time like you are.
there are questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to
they wouldn't have rested if they didn't think they made their case.
Correct.
If you want to,
it's clear.
If you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses. That's
if you're asking me to strike their testimony
Good.
based on your
I didn't say
perceived,
anything
then that's
about that.
Good.
all right.
Yes.
Then I'm going to bring the jury back out. And you're going to call your next witness. So I'm
So
not
is
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
Well, I disagree
Oh, yeah, you
with
are.
that, sir. Again,
You're
you could ask
All
questions
of a
to
sudden-
lay a
all of
foundation
a sudden the
with
state
these
don't got
witnesses.
all of a sudden for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just not.
Why do you want them to cross you?
This is argument on your part,
I
sir.
see
It
through
is
it.
pure
I just
commentary
want
at this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in fact.
I know that's what the state does.
You could
Come on,
ask
man.
these questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and you're
far,
not.
far from the idiot.
They're your witnesses, sir. If you believe
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for. Have they been coached to answer the way they answer? Because
well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other
You're
witnesses.
mad that they're
find it
not
very funny
crossing your
These are their
witnesses?
reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's no
recall seeing
purpose
somebody
for you
reach for
saying this
something
right
and
now.
don't know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm instructing
You
them
can literally
to
see
write the
desperation
commentary when the
setting
jury
in
comes
this
out.
guy's
You will
mind.
find your right to be
I didn't say
present.
It's very tiny minds.
Oh, good Lord. That's the dumbest thing I've ever heard.
Witness by the name of Abel Lescano. He has prior criminal
I
history.
would love if nobody crossed my witnesses.
So as
Yeah.
long as the jury's out,
No,
we should
right?
probably
But of course,
discuss that. I would like
he sees a
to
conspiracy.
He's feeling like an idiot.
That had to be said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to
Come on,
benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit me,
witness
so let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Stop talking.
Come on, man. Who y'all be thinking y'all fooling? I'll set the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from
Right,
2006.
I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
That is a death stare.
We're taking a
Yeah,
break.
what is he doing?
That is a death stare. That is an I want to kill you stare.
He is not helping himself in any way.
The judge just said that?
Yeah.
The judge said she was scared of him.
Yeah, she just said she was scared.
I like her. I think that's a mistake.
I don't blame her. Did you see the way he was looking at her?
Oh, it was completely psychotic. But put him in another room. Make a record of it. Say, I'm not tolerating this.
She said she needed a break.
I would too.
That was.
Oh, good Lord.
That was steep. That look. That was an I want to charge the bench kind of.
Oh, it was bad.
Well, to me, that made it clear why we're here. I mean, like,
that's why. I mean, John's been with me on this for days, but that's why I texted Lily, and I'm like, she's like, "Well, let me see if I can," and I'm like, "Oh, it's gonna suck."
That was.
I'm not inviting you to a fun party here.
That was his worst moment that I've seen.
That was terrifying.
Oh, that was
I
terrifying.
mean, if I was the judge, I would be like, "Get this guy out of here."
Yeah.
Absolutely not.
Oh God. All right.
I don't know. I don't know what you do.
How do you complete without explicitly denying him the ability to continue his defense? How do you complete this with somebody that behaves in that way?
How do you deal with it?
He seems to somewhat behave when the jury's in the room.
Sometimes.
That was terrifying.
The only thing, though, is they got him right there. They got shot cuffs on him. I guess I'm a guy, but I just plow ahead. I'm like, yeah, I get what you're doing. I don't care. Let's go. Let's roll.
Bring the jury back in.
Because he's contained. You got bailiffs and you got shot cuffs on him.
Yeah.
Well, I mean, let him make that face in front of the jury.
But that's easy for me to say.
Well, no, making that face in front of the jury, prejudicial, sure, but appropriately so. But we've seen cases in court where the shock cuffs don't necessarily work properly and people try to jump the bench. I've seen it, not personally, but on videos.
I mean, and she's probably safe, but I mean, she needs a breather. That was intense.
I think that she needs him. I think what she's hoping for, one, she needs to go probably step out and get some air, maybe take a smoke. I don't know if she's a smoker. I think she wants to give him the 5 minutes to chill the hell out.
Maybe a White Claw to take the edge off.
Yeah.
No, I think she was genuinely terrified. That was, if I was in the room,
I think she genuinely
like
was.
that, I would be like, get me out of here. This is terrifying.
I think she was genuinely afraid of him.
Yes.
But
yes, Kathy makes a good point. We did want to see the actual use of the shot cuffs. And that's really my main problem here. I'm not thinking so much of the appellate record.
I think as a practical matter, I agree. I think that she actually was afraid. And I think that she's hoping that in 5 minutes, maybe he cools down a little bit and they can proceed. And she doesn't have to go through the whole freaking colloquy about getting him tossed out of the court again.
Well, I think we'll start there.
I think that's very much where we're going to start.
I think we're going to have a half hour of which courtroom do you want to sit in?
Yeah, you're probably not wrong.
I
That
can't
was
for all
a death stare. If there is anyone.
That was, well, to be fair, I thought for a second there, I thought that he had just gotten mad in the moment and that his camera froze. Like I thought maybe the connection went bad, and then I could see things moving in the back, but his face wasn't moving. And she started talking, and I'm like, oh, no. Like he's still doing that. That's still his face.
No, so when he started doing that, I flipped over to Twitter to thank everybody and genuinely thank you everybody in chat who subscribed for the 2,000 subscribers. And then I came back and he still had the exact same expression of like, this is kind of frightening.
Yeah. I see why water bottles are no longer allowed in most courtrooms now. 'Cause, yeah, those would be chucked, I'm sure.
Yeah, there was the old days when you used to actually be able to get a pitcher of water in a glass.
It depends on where you
I think
go.
we're past those days.
Yeah.
But yes, genuinely, thank you everybody who did subscribe. That was heartbreakingly like quick. How many people showed up in that period of time to put me over the 2,000 mark? So thank you everybody, and thank you Mike for having me on. And
where are you at now?
To meet all these folks. They have about a 2008.
Oh, nice. That's awesome.
2062.
Wow, a lot of people.
Yeah, that's 300. 2092. That's like it's like 250 people in the course of about a couple minutes.
That's awesome.
That's been great. You all are absolutely amazing. You have the best chat in the world, Mike.
I really do. But you deserve it, man. You've sat here and just taken the psychological punishment that is this case for, I mean, day in, day out.
That's all good. Lily, you can do it too. This is over the course of like a week and a half.
I am out of PTO. I get married next month and I have used every single day I possibly can. So I'm like hopping in between mediations and hearings as much as I can.
Now, I do this during the day, and then I have about 4 hours to try and deal with some private clients that I have. I'm not currently with a firm. And then the rest is sleep, and we just do it again.
I just do this all day and dump everything in my assistant Yesenia.
I mean, that sounds great. That's the life.
That is.
Not everybody has such a fantastic assistant, and not everybody's collecting all the super chats.
I do have an amazing paralegal, but I only got here today because my mediation was unsuccessful. So
It was successful or unsuccessful?
Unsuccessful. We did not settle, so we got done, earlier.
I hope you guys get sent to Judge Manning for a pretrial right away.
I wish. No.
Pretrial. Oh, that's the whole time. I know, but that's the whole time.
Say the word. Oh, and go ahead and put yourself on mute now.
The whole time watching that stream, that's all I wanted.
I need to watch that because Charlotte Rubel, she was the first attorney I ever worked under after school. So I'm very familiar with Charlotte Rubel.
Oh, there's been some wild ones over there. In fact, John and I stopped by. She was doing like pre-trials yesterday at the end of the stream, but just for like a minute, just for some therapy.
Oh yeah. And just as a reminder to everyone, I have a little bit of therapy if you're interested. I'll run out the stream whenever court ends today. I just have a couple quick things that might be fun. Obviously, Mike's interested. If Mike wants to join, he's welcome.
Do you have that put together, John?
I have the paperwork put together. I think it's always going to be the technical nightmare because I'm awful at this, but I at least have the paperwork, and you know what? It's 3 pages that we're going to go through and just kind of chat, which would be fun.
Thank you.
Congratulations, Lily.
Thank you. We're excited.
Yeah, we are. Hey, he's a lucky man.
Okay, I think I might have missed some super chats, but it's been crazy.
All right.
Okay.
Step away for a second.
Okay, we got that one. Sorry, Chuck, he's not here. I'll say Chuck in Tennessee. I don't know if that gets it done. Oh. Yeah, I know. Lawn lumber. That I think John's thing will be short. It might be done before lawn lumber even starts up. Yes, I think he will snap. I don't see how this can go on. You just can't act like that in court. I understand they want to protect the record, but you can't look at a judge that way.
Mm-mm.
And it's not just like one time, like, oh, someone's mad in a moment. He's been just nasty for days on end.
And I know he didn't say anything, but that was threatening. I mean, that was,
Oh, yeah.
he slammed his fist on the table and then did it like a death stare. That, I took that as threatening. So
I think that's what it is. It's so funny, too, because he's like just a little guy.
yeah, well, he can do damage.
You know, he's like a little tiny dude, and he's like pulling this routine. You just want to thump him. Like every guy in the planet would under these circumstances.
Yeah,
that's part of it. That's part of it. It is the insecurity he's got.
And this poor judge. Oof.
Yeah, John doesn't. Okay, so I pushed John into it, and we ended up doing a live stream. You know how I am.
All right.
All right, there you go.
On.
John is prepared for his live stream as Brooks is for his own witnesses. Absolutely. So
yeah,
I forced John to do it. He does a live stream. I get on beforehand. I'm like, dude, you don't know what you're doing. Turn that thing on now. And I'm yelling at him.
You know what?
But we got it done.
At least I don't have 15 minutes of dead air before the freaking stream comes on because I don't know how to hit the start stream button on StreamYards.
Yeah. Well,
I'm getting better. I still don't have a thumbnail.
Well, no, I get the implication here. No, the bailiff can't just go over and drop a tase on him or something, or you know.
Unless he did something. I mean, if he started trying to come across the
Right.
table or something
Sure.
like that, then obviously yes. But
Oh, believe me, because every one of them wants to. Every one of them wants to. Just drop him in one.
Oh, Lord.
Oh, they all want to. Oh. All right. Well, are they ever going to come back?
Well, you guys, oh my God. I'm at like almost 2,200 subs now. You people are freaking amazing.
I know. Lily, all right. I'll leave you alone. You go get married and have your honeymoon and all that crap. And you come back, you're gonna have to start a YouTube channel.
I am all about it, but I need a lot of help. I have no idea what I'm doing. I just created a Twitter account the other day when you posted it on Twitter. I'm like, well, I guess
You're halfway there. Well, you're on here, so you know how to do this.
Well, right. I mean, you send me a link. How hard can it be? I just click the link.
That's how I started too.
So that's basically it. I mean, as far as actual YouTubing, I don't know. I mean, I dropped the stream earlier because I just, you know, I don't know what I'm doing.
I'm all about it if you will be my mentor.
I will help you out. I will help you. I will. I mean, they love you here. Same with Ben. Ben comes on.
Nice.
Same with John before he started a channel. They're like, we love him when he started a channel. I'm like, I can harass him a little bit, but that's about it.
It's also very nice of you that you would encourage that of other people. Because I feel like that could somewhat be a little bit of competition, but I guess not.
Oh, and folks don't know, like, behind the scenes, Mike and I text back and forth, and he's absolutely incredible behind the scenes as much.
Oh, I know. He's like you too. We have great conversations. You just wouldn't expect that, I guess, of somebody who's got, a YouTube channel with a big following. So it's been nice.
Well, I'm in no competition with John because he's actually attempting to teach people things.
Yeah,
which is just completely what my channel is not about.
Correct. I think people learn stuff from
There you go. If I can do it, anyone can. That's the truth. That is the stone cold truth of the matter right there. All right.
If you can do it, anyone can.
I got this, and I took this as who said this? It was in my comments somewhere, so somebody said it. They're like, I can't believe how far this channel's gone with this low of production value. and I take that as the greatest compliment. I'm like, thank you.
You know what? That is a compliment.
I'm like, thanks, I guess. You know.
Yeah, I had an attorney at my firm even reach out, and he was like, I'm so jealous. Like, Mike, I've been following him, and like, I've been watching his channel. That is such a big deal. I'm like, thank you.
Well, I will say this though, because I've done a bunch of stuff. Like you responded. Some people have, you know, Deborah Davis was really cool. You know, Ben Bateman was really cool. A lot of people don't have the guts.
Yeah.
I mean, all I did is like, I happened to be. It was a lot largely because Judge Manning's a hoot, and I'm doing this hearing, and then you get into this stem winder of a hearing. Everybody thought it was interesting.
Yeah.
And they do this to me all the time. They did it yesterday. They look, we like this witness, have him on the stream. I'm like, I don't know everybody on the planet. So I literally just send an email to you. I'm like, she's going to ignore that. Which is fine. That's the appropriate response. So I send her an email. So because a bunch of people asked, I'm like, then I can say, well, I emailed her and she didn't return the email. What do you want?
Yeah.
So Lily's like, yeah, hell, sure, let's do it. Why not?
Well, I remember getting Facebook messages over the weekend, and I just kind of like never looked at it. I just thought that they were, I don't know, spam or something. And then I think the link was actually sent to me, like, you are on YouTube and it's blowing up. You should probably watch it. And I'm like, oh. And then I saw your email. I'm like, well, okay, I'll go on there. Especially because people were being so nice. I was reading the messages and everyone was.
That was a wild hearing, though.
Everyone was making me feel good about myself, saying I was being a good attorney. So I was like,
you were being a good attorney. It was a perfect setup, though, because your opposing counsel was just embarrassingly bad. And then you're like plowing along, just doing a nice job, like representing your client. And but the comparison's even better, you know? It's like,
Yeah. Well, I mean, it's easier to say I'm a good attorney when the opposite is acting so crazy. So.
No, I want to echo that comment as well, because I had somebody yesterday who I had not spoken to since law school and saw us on the stream over the case yesterday. And it's the craziest thing, what kind of reach this platform gets. It's nuts.
Yeah.
What I can't believe right now is we've been going away, but like we've got 3891 with us right now, which is awesome. And that's huge. And I'm so happy, but like we're in a break. We've been in a break for 15 minutes. We don't know when court's coming back.
She said 5 minutes, but it's been more than that.
God bless y'all.
I hope she's okay. I mean, I wonder if she just kind of.
And by the way, not for nothing, my subscribers are now at 2218. So I got almost 300 subscribers in the course of about 10 minutes. Because
now I'm feeling competitive. Now I've got to create a channel.
You're all the best.
You'd knock it out.
Oh, Lord.
Okay.
Have they been stopping at 5 o'clock pretty much every day, like on the dot, or has she let it go past 5?
No, I mean it's varied. She went to like 6 one day.
Oh, okay.
Yeah, she did. I think that if she thinks that, I don't see that there's any way that he closes his case today. So I think she might cut it at the last witness at around the 5 o'clock mark. But I just don't know.
Mm-hmm.
Wow. But here's the ultimate drama. I mean, we've had lots of back and forth, but that psycho glare was I mean, there's been lots, but that was the height of drama so far in this case.
That was terrifying.
I'm actually genuinely wondering if part of what's going on right now is she's having her clerks determine if she could end his defense and just move to the end of the trial.
Yeah, that's a good point.
Yeah. All right. Elaine's giving out virtual hugs. We like that.
I think
Yes
she
and
might
no.
actually be. I think she might actually be considering sua sponte ending his case.
Here's the thing about my chat, though. My chat misbehaves, and I don't know where they get this idea. I don't know where it comes from. They do, but they're not. But they're funny as hell, and they get it. And here's the other thing: is half of them are attorneys and judges. They just come here to misbehave. I know who they are because I get the DMs and everything. I know not all of them, but like I know what's out there. Okay.
Well, why do you think I ended up starting to join your chat?
So we'll get like 3 immature comments in a row, and then we'll get some like seriously like
erudite,
intricate thing, which I'm like, oh, okay, you've been doing this for 30 years. All right, that's clear to me, and that's my chat. That's what you're dealing with.
Best chat in the absolute business. Oh Lord, God, they gotta get back by now. It's been.
There's
I
a
think
head.
we might be having people back. There's movement.
Somebody walked by the camera in an empty courtroom. I'm very excited.
I believe that was one of the prosecutors.
Yeah. That was some freaky deaky stuff. So Lily, this is good. You're hanging tough with this too, like, and that's what's kind of fun about YouTube. But then you have moments like this. But what do? You sit here and chat.
I do, yeah.
You just roll. Yeah.
No, but as a practical matter, that stuff got dark real fast in terms of his behavior. Like you saw just like that sort of soulless stare.
We're not learning.
All right, fine. You know what? Then you get party on the top and learning in the middle, and you got attractiveness on the bottom. So you know.
I'm like, what is he about to say?
Oh, good Lord. Okay. Oh, all right. We'll do that. You want all right. You talk me into it. We can do one 20-second round of that.
Oh my God, is this Blandino?
Oh, it's Blandino. Why not?
All right,
because
why not? Let's do it.
That was Ben's client. Let's do it. Let's get it on. No.
Oh God.
Okay, I'm assuming that's a yes. Okay.
So that's who Ben represented, Kim Blandino, who, by the way, is in jail right now, waiting for a hearing on a probation violation. It gets very technical. And he wants to do a stream with me from jail. I'm not kidding you. This is the world you've walked into, Lily.
Okay.
It's not a bad world to be in, honestly. Of all the worlds you could be in.
I think I'm going to put that together. I do.
You should.
So, and okay, here we go. Let's do it.
puppies. All right. I gotta mute myself. By the way, geez, guys, 2268 at this point on my subscribers. You people are absolutely the best. That's like 300 in the course of 10 minutes.
Before-
You people are fantastic. Thank you. Thank you
I'd like
sincerely.
to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir.
Like Yeti, he's
Right, then.
pretending to read a Bible.
Oh, we do.
You're
I
presuming
knew I would
Hindu.
left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that would not have been a crime, but everything from OWI second on down, we believe.
Thank you.
Appropriate. There's also one that's noted, 06 CM 2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk. And then remind me the statute again on priors.
Nobody could ever replace secret, but
Thank you.
absolutely interesting.
I'm gonna have to go Uber Eats again.
And a copy of the record was provided
Yeah,
to
I'm
the
getting a
defendant.
snack.
It was. It has not been discussed with Mr. Lizzacano.
That was going to be kind of my next topic once. Thank you. I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
I don't understand that. Here it comes.
What? I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't
No,
think
there was one state's witness that had one prior that we discussed. and
that's
the court
right. We
ruled.
did. I recall now. So at that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your
pretty much
attention
right.
to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
I think his brain might have actually melted over the course of the break.
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039. 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in. 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that file.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
You built this community, Mike. You're responsible for that.
What is dismissed and read in? Does that mean there was no charge?
No, it means it was.
I'm contemplating some Geno's East.
For something
I'm not
else.
sure yet.
The charge was dismissed and read in, and then the court considered it at the time of sentencing.
I'm
So they are not
contemplating a high-speed lead
convictions, but
injection.
it was a case, so that's why my understanding why it was listed.
So the 2. So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
Thank you, Pat.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI?
An OWI first would not be a crime, it would be a forfeiture.
God, being a lawyer is so difficult. Particularly when you have no training or education whatsoever. OWI is operating while intoxicated.
There's continued OWIs. All the way up to a 5th.
I will be your Price is Right.
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Thank you, Crystal.
Well, it'll be less than 7. He has 7 convictions as I count them.
There's one more word there.
And that's not counting OWI.
We all know it.
First.
Correct, because it's not a crime. It can't be counted under the statute.
I have never pulled for a tase more in my life.
Should be 7.
All right. Do you want to make any argument
I
about
don't
whether
know.
any should be excluded under the
I'm
statute?
going to fight with you, Mike. Deep dish
Based upon
pizza
the
is
factors
not
I just
pizza.
read to you.
It's a freaking
Well,
casserole.
You already made
The only actual
reference to
pizza
one
is
of
New
them not
York
being a
pizza.
crime. So that brings it to 8. I don't.
I'll fight you on that.
understand The whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
She's like coaching him along a little bit.
Yes, she's been doing that a lot this entire time.
Speculate on the next man's life.
Mike and I have gone back
If
and
it's
forth
7
on
on
it.
here.
I think both of us are strongly of the opinion
Well, I guess
that
it brings it to 7.
when you represent yourself, you should be treated like an attorney, but obviously
Whether OWI first
you
is
can't
not a
do
crime,
that and
it's-
still have a clean record.
Yeah.
So that's kind of what she's doing.
It still counts as a what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then. Anything further from the state on this? Given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did
I've
complete the
stored walking
release
distance
program,
that they bring in water
which
from
would
New
have
York.
resulted in a reduction
Just to
of
try and make the
initial
appropriate New
confinement,
York pizza,
and then
which is
converted to extended
pizza.
supervision. I don't see
You don't call it deep dish. You don't call it
violations
Chicago style. You just call it
of
pizza.
probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons.
John Stewart had a
Well,
great
given that there was
monologue
a
on
pattern
that.
with the OWIs, that the last one was a felony, that goes to the gravity of
What-
the crime.
What are we even talking
And
about?
the other issues, I'll find that for purposes of his testimony, that this witness has 7.
Is he about ready to testify himself?
He may
And
be
what
asked,
convictions are you going to
convicted of a
eat?
crime,
Is that the question
yes.
here?
And then the follow-up, how many times?
To some
Yes.
extent, I think. I don't think he's the one testifying. I think the issue is that they're trying
Yes, Your
to.
Honor, I believe.
He's trying to do a motion in limine, but he doesn't know how to
Stay
do
willing
it
to relay that
as it
information.
relates to his prior.
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
Right.
Absolutely.
Who's your next witness? Will it be Mr. Lascano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
For sure, Mr. Hayes and Mr. Lascano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
Right, so Hayes and Lascano are still here.
Yes.
All right. Those are the 2 who are here, sir.
No, pineapple does not belong on
Tell you what,
pizza.
either way, let's just bring Mr. Lascano
Everyone in this
in
chat
case
will
he's
agree
not
with
here
that.
first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him.
Okay, I think the next witness
Someone from-
has prior
Victim witness can
convictions,
bring him in, please.
and they're trying to keep him from
Can I have
bringing
first
those
name
up
of his witness,
during the direct, which is so
But I
freaking
believe it's
stupid. If you have to impeach your own written witness, don't call them.
Correct.
Okay.
A pizza war has broken out in my chat.
I know.
Thank you.
This is what happens. I'm like, I might get some Gino Z's.
Subject matter
I
jurisdiction.
figured it might be more fun than the ginger question.
Still has yet to be verified and put on the record.
Your objections noted.
Here, I'll throw them all off. How about Silo and Lake Bluff? None of you know that. How's that?
I have no idea what that is.
I mean,
You want Mr. Lascano on
that's
the
how we
case,
all
or you
feel,
want Mr.
buddy.
Case first, just so I know what to do when he comes in.
I don't currently
Pineapple
have,
and Canadian bacon
paperwork
might
from
actually
Mr.
not
Hayes.
be a bad combo.
A police report or something be provided in case I want to call Mr. Hayes first.
Thin crust?
Yes,
I can
we
see
will
it.
accommodate that request. It'll just take me a minute, Your Honor, to find it. I'll have to have it printed and brought over, or Mr. Witchow can run. Thank you, Mr.
I will give you
Witchow.
permission to email it to Teresa and she can print it in the courtroom. That
Well,
will assist.
it's part of a 700-page PDF, so I can't just email one page.
Yeah, ketchup on hot dogs is also illegal in
I
New
don't
York.
want to do that.
The only proper condiment is mustard, sauerkraut,
You can
and
do it the way that you
cart
need to.
water.
All right, Mr. Lascano, I'm just going to have you for a moment take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand.
Maybe
I want
onions.
everyone can have a seat.
I
I want to
can-
advise you
onions
that
can pass on a
I'm
hot
aware
dog.
you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that?
Yes.
Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can roll back out and go forward then. Thank you. All right, then let's have the jury brought out, please.
Oh, good Lord. Let's do this thing. Let's go, people.
Hey, we still got at least 2 hours left. I'm in for the ride. You already started cracking the White Claws, so it's Friday.
All right.
I agree with your chat. I think he's going to explode.
I still say this is a better defense.
You didn't say the cat jumped on his wiener, did you?
Seriously, better than anything he's come up with.
He hasn't come up with anything. Every
Thank you,
one of his
everyone.
witnesses
Please be
hasn't
seated.
advanced his
The defense may
argument
call its
at
next
all.
witness.
Well, the clips aren't so loud that the feed is really quiet. It's very difficult for me to adjust.
Jason.
Seeing as though I don't know what I'm doing. Okay.
We'll have the witness brought in.
I mean,
Okay,
I have secret mad at me
We'll do it.
because we're apparently too loud over the court, but I can't do anything about that. That's StreamYards. There's no way to actually handle that.
Is it Haynes or Hayes? Does anyone know?
No end to the best of my knowledge.
Hayes? All right, good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hays.
Thank you. Go ahead, sir. Your witness.
It is so quiet. Sorry.
My mom liked mushroom and onions. That was never really my thing.
I accept
But
the
it's not
value
bad.
in return for value this document for the record.
Why is the court so damn quiet all of a sudden?
Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep.
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide.
Been doing that for a long time?
21 years.
Yes, a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
What were
I
you
would
doing
eat
that
extra
evening?
cheese and pepperoni 100%. And that's
To the
the end
parade.
of my discussion.
Were you scheduled to do any marching in the parade itself, or
No.
just spectate?
I don't know why the volume just left.
It just dropped off the face of the earth, right?
Mhm. I'm trying to make every adjustment,
Did you say yes to being a spectator?
which
Yes.
for me is the
Thank you.
volume. Like I
I just
maxed
wanted
it.
to make sure there was.
Yeah, he answered. He answered. Anything unusual catch your eye that day that you recall?
Yes.
And what did you see?
Does anyone else notice that Lily always looks like she's a
Besides the
board
parade?
Instagram model?
Yeah, I'm sorry. That
Looks
that
like
was
a
the
what?
unusual that caught your eye.
A board Instagram model.
Well, where we were, yes,
I don't know
Sorry.
if it's compliment or not.
it honked and swerved.
Sorry.
I mean, this can be a little boring at times. I'm not gonna lie.
Where were you positioned at that?
We were all the way at the beginning of the parade.
Okay.
Like it was Main and
Especially since he
corner of
can't hear
Main
it, but I
and
don't know what to
White
do.
Rock.
Okay. And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it? I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
And you stated that the vehicle honk was that just a single honk, or was it a beep beep, or
One honk.
do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
I don't recall.
So well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going.
What happened?
I think Mike's trying to do some technical work on the back end. I don't know what his argument here is with this witness.
And I'm assuming at some point you were
That's better. A little bit.
Either were interviewed by law enforcement or seem to be.
Just change feed.
By law enforcement.
Yeah.
I did, by a detective.
And do you recall if that was the same evening or?
It was not the same evening.
So
it was a couple days after.
Yeah.
He keeps going back to honking the horn. That's like your worst defense.
Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes.
So in your opinion, it wasn't trying
How
to
does
strike
that help you?
Correct. Yes.
That means that you had your wherewithal and you chose to hit the people
after
that
it
you hit
continued,
in
I
the
think you said
parade.
east.
Yep.
Would that be correct? East?
Yep.
Did you see the vehicle strike anyone?
I did not, no.
This is the worst defense I've ever seen. Maybe not the worst, but it's up there. The point that you want to attack is the form of intent.
Do you recall what side of the street the vehicle was traveling on at that time?
It was on the right side.
The right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Okay. Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road or?
No.
Yes, Joe Tracy, this is worse than yesterday because he's continuing to bury his own defenses.
No further questions at this time.
Thank you. Any cross?
That's what you brought it there for?
Good afternoon.
Oh, praise the Lord.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw
I'd be making a lot more money.
chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that?
Hold on, there's been an objection.
I guess the objection to be what officer is being referred to wasn't clear.
Overruled. The statement, continue asking the question.
I guess I was asking what was that referring to?
We know what you're asking, jackass. She overruled it.
Objection is noted. It's overruled. The statement asks the question fully.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody beyond those descriptions, correct?
Oh, he's
There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
That's a perfectly clean cross.
Briefly, very briefly.
Oh, briefly. Briefly. A little redirect
made a
examining.
reference to the driver of the vehicle having a dark complexion. What would you consider a dark complexion?
Yours.
Dark complexion. I don't know.
It is kind of hard. Did you notice any clothing?
I did
on
not
the driver?
know.
Did you notice any hair?
No.
No further questions?
All right, thank you. You may step down.
What the hell was the point of that witness? Oh my god.
The defense may call its next witness, please.
That's what he does every time.
I know, but it's still every single time. I'm struggling.
Quick question before I do. Who's supposed to be arriving?
It's 4:30 in the afternoon
Just
here,
on.
and I'm starting to lose my freaking mind.
Idiots and Darrell will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
This is not allowed in my chat, okay?
Be clear.
I'm cutting this off right now.
Are you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right, then he may. The defense is calling Abel Liscano, correct?
Yes, my baffled meter is being
Defense is
overloaded.
calling Abel Liscano.
All right, very well. We'll have him brought in. Thank you.
Once again, you might want to work on your witness's name if you plan on calling him that day.
That could help.
I mean, it's slightly out of the norm, but you kind of page ahead and you think, all right, how am I going to say that when the time comes?
Good afternoon, sir. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. And my clerk, Teresa, who
No,
will be
he's not allowed to
accountable
have
for you,
questions
and the
anymore.
prosecuting will swear you in.
I think that he lost that privilege.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell.
Oh, Michelle, you think I haven't yet?
Adelazcano.
Thank you. Your witness, sir.
Good
I'd
afternoon.
like to make a motion to
Liscano.
allow the witness to just pound the defendant senseless
We do
himself
for a
because I think he's capable.
I'm a hairdresser.
I'd like to make a motion, trial by combat. I will operate as champion
No
for
judgment
Speed
whatsoever on
Wisconsin,
this
and Mike
question.
is my second.
Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Yeah, try that death stare in this guy, jackass. Go ahead.
Yeah.
That's gonna go well.
Do you recall the night of November 21st, 2021 pretty well? No, it's been a minute,
Best as I can, yeah.
but what were you doing that evening, if you recall?
Christmas parade?
Were you marching in the parade? Or?
No, I was watching it.
Yeah, trial by combat between Brooks
Who were
and
you
the
there
entire
with? Family,
town.
friends?
My wife and my daughter.
Do I look like I was marching in the
Do
parade?
you recall
Just
where you were?
think about that.
Position to watch the parade.
Standing in front of the Corey Insurance on Main Street.
Is that part of Main Street close to like a side street? If you recall,
not too far from Maple.
Do you recall the side streets being barricaded during the parade?
I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And
you murdering 6 individuals?
Did you see the driver of this SUV you're referring to?
Yeah, you're standing right there.
Why did you call him?
Wait, yeah, what just happened?
This is not going to go well
How
for
many
you.
people did you see in the vehicle?
Oh my God.
Just one, the driver.
All right, I need a second.
So,
Oh my gosh.
do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
You know what it takes for a convicted felon to flag down a law enforcement vehicle?
Yeah.
See if
A lot. Yeah, absolutely.
bring back to recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
Yeah.
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
And
I
do you remember
apologize.
what the
I need a
description
second.
was that evening that you gave to law enforcement?
Told me it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
And I know he was you.
Is that all you recall about your description?
That's all I remember.
The fact that the state didn't call this guy is incredible to me.
Oh, well, they'll have a field day on cross, I'm sure.
Oh, God. And this is what they were doing the motion to eliminate over his past background? Who cares? You're a convicted felon
After seeing this
with a
vehicle,
long
what did you
rap
do?
sheet. And you called the cops because somebody murdered 6 people.
We left. I got my family out of there.
That makes you extremely credible.
And where did you go?
At least on
We
this
headed
matter.
back to the car.
Do you recall where your vehicle was parked?
Oh, the jury loves him. I guarantee it. I guarantee it. I've been doing this a long time.
Oh, God.
On Maple Street.
I think there was probably an ADA that was like, maybe we shouldn't have him on because of his past record, because it's open to attack.
Did you
by
see the
the
vehicle
defense.
stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
But he called
No, I didn't see it stop. No.
for the prosecution.
Kept going through the parade.
And
Oh,
speaking
Lord.
with
No, he's doing a fantastic job.
Detective Moss. Well, speaking with law enforcement that evening, do you recall advising law
Since
enforcement
the Lincoln administration.
that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the
Yeah, and if you had a proper
the witness this. I'm referring to page 4 exactly.
Is it a statement this witness personally wrote?
I believe it's what I don't think he wrote it himself.
So it's a summary written by another person.
By I don't know if it's Officer Moss or Detective Moss. I'm not sure if what his rank is.
Continue with your questions. I'm gonna
deny the request that you show the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other two were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Great witness.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as two short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him. I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
Just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. You were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car, trying to get them to safety. So I was keeping an eye out, and I spotted it.
Is that better?
I don't know. How's my sound coming through?
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Thank you.
Yeah, well, that's not necessarily a technical issue.
Thank you.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to
then I don't look as pretty.
Was ultimately found?
Yeah.
Where the fuck is Greg? Sorry, one of your chats just.
Do you recall yelling at subjects standing outside of the building where, or near where the vehicle was that evening?
That would be a no.
I don't remember yelling at them.
Do you recall why the report says that
this is a hug?
you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
I thought the chat would like that a little bit. Yes, I'm wearing a robe. It's fluffy and it's enjoyable and it's like a hug getting through this nonsense.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective that evening, if you recall?
Yes, I did.
Do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with 2 different law enforcement officers that evening.
Yeah.
This is not the car you're looking for.
Do you recall in your
I'm okay
interview
with that.
Detective Coates?
I wish magic were a thing and I would be an evil wizard.
In reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
This witness
Do you recall
is
in
thoroughly
your interview with
unrattled.
Detective Coates that evening?
So what's
stating
the
that
one yesterday?
could
He was
not provide
fantastic
any
too.
description of the occupants.
Why
other
would you
than
subpoena
that
them?
they appeared to be African American.
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people is because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, and it is in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that
It's
evening,
not.
do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
That last super chat, that is what I was saying and how you might
Any
be
reason
able
why
to go about it.
the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Do you recall in your interview with the detective coach that evening stating that the three individuals, and I'm referring to who you saw next to the vehicle, so it's clarification. The three individuals who were standing in a line, shoulder to shoulder, as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least two of them. And looked like they were standing in front of it.
Why does your chat always want to make me snap, Mike? I try to be fun, try to be friendly.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male? So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male?
I don't remember.
Thank you. I was mostly joking, and I understand that it's all in jest.
Any reason why multiple?
That's why I'm doing it.
I'm not gonna say multiple. Two.
Because this
Any
is
reason
too
why the
hard
two
to sit through otherwise.
detectives that you spoke with that night both reported that you stated you saw three black subjects running from the vehicle?
No.
Good luck getting through character and fitness, jackass.
And during the parade incident, were you or
I don't know, I did.
were with injured that evening?
No.
Did you murder 6 people with a
No
car
further
during a
questions at
Christmas
this time.
parade?
Thank you, any cross?
Yes, Your Honor, thank you. Good afternoon, Mr. Lascano.
No.
Sir, you said you watched the
Can
parade
you
near
tell us if
Curry
you did?
Insurance, is that correct?
Yeah, right in front.
Okay, do you remember, you said you saw the SUV strike some people in the parade? Yes? Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection, leading.
Overruled, it's cross.
No, I don't.
Speculative. Objection.
Overruled, the witness may answer, and David said no, his answer may
Yeah,
stand.
no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection, speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection, speculative.
Oh my gosh, he's annoying.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I saw it coming through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in the air.
You remember that?
Yeah, it was right in front of us.
Okay.
And while the witness was giving the answer.
No, he has not gotten
the
less
last
stupid.
answer, the one prior to that, he had his right hand in the air, directioning
his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
So, Mr. Liscano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Go ahead.
Oh, what did he open the door to? That they're publishing.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may.
It's already
proceed.
been received, so who cares?
This total clip is 36 seconds, but before we begin to play it, sir, do you recognize the area on the screen that's shown in this picture?
Yeah, I believe that's Central Middle School.
Where?
Oh God, he is.
Right at where the
He's
stairs is.
murdering
Okay,
himself.
the red brick on the left side of the picture?
Yeah.
Objection
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection leading.
Overruled.
Welcome again to Law Talk with
May
Sean.
answer.
Yes.
That looks right, correct, sir?
Objection leading.
I'm back.
Overruled.
All right, we're gonna
I only had a couple seconds.
clear the screen,
No fun.
please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular.
It's your witness, idiot.
You may play the clip.
Overruled on what grounds, Your Honor?
It's within the scope of the direct. Oh God. We're off to a great start.
Is that attacking agreement?
I needed to.
Sir, did you see yourself or your family in that clip?
Objection speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 more people. I don't know if they were, I'm sure they were white, but I was trying to not make it obvious at the time.
The
I
state
believe
is
that they
mine.
were with the
I
vehicle.
We have found
but I
Wisconsin.
didn't see that I saw them, so I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection speculative.
Overruled.
No, I did not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection.
That's actually a good speculation.
Crash mentioned.
I'll sustain.
And that's not the one that he went with, but he's still. Oh God.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety, just like you were, correct?
Objection speculative.
Overruled. The witness may answer.
Yes.
You didn't see anything like that in State's Exhibit 65, did you?
No, I did not.
Of course.
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection.
Granchi, you're presuming I haven't been.
You
And
said
it
that.
mischaracterizes the testimony because that was not testified to before on direct.
Oh, yeah, your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it.
you?
No.
Okay, just wondered. I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You ever heard her ever talk about this case through your testimony?
Objection, hearsay.
Overruled.
No.
Mr. Witchow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection, hearsay.
Oh, good Lord.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
I've got to run, guys.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No.
I'm not.
I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the color of clothes you were wearing. I knew it was a black male and had a scruffy beard. The first thing I told my wife was he was a black guy driving.
I didn't pay attention to what color clothes you were wearing. I love it.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And in a couple seconds time, you were able to make out the driver's profile and race just by a couple seconds.
Yeah. It's not hard.
Mike, I think chat's
So
saying that
if you were
Lee's
black,
trying
you had a
to
beard, and
get
I
out of here.
What color shirt you
I
had
want to
on.
say goodbye and
Hair,
all that good stuff.
hat on back
Well, are
there.
you trying to leave?
Yeah, I gotta go, but then I got interested in what he was gonna cross.
So that leads
All right,
back to the
cool.
question.
Well, thanks for coming by. Leave whenever you feel like it.
Thanks,
Always
guys.
pleasure.
Bye.
Bye.
Is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's the only reason.
Would it be fair to say that when you spoke with 2 different detectives that evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you? Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives, two different detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade, why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
So what's your question?
The question is, why did you report that to 2 different detectives on the same evening?
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both interviews with detectives that evening, the evening of November 21st, 2021, you also stated to both detectives that you observed 3 or 4 Black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
No, I don't remember.
No further questions.
Thank you, sir. You may step down.
Again, is this the mistaken identity argument?
We have additional witnesses here.
Yes, Your Honor, they're ready.
It just is going
All
nowhere.
right, will that be
We got
how
you.
many people?
There's 2 left.
Okay.
We have video of you in the
Your
freaking car.
next witness, sir.
Pictures next to the car. The car's plate goes back to your mother. You had the freaking key to the car in your pocket. I mean,
Oh, God.
One
your
quick
DNA
second,
comes
Your
up on
Honor.
the
One quick
steering
second.
wheel.
Go ahead.
If you're wondering where the after party is going to be in Tampa, I'm going to probably the retreat. It's one place you can smoke indoors. It's just, this is so stupid. I don't know what he's trying to accomplish by any of this.
It's a slight deviation from the narrative in the race card. That's what he's trying to drop there.
Barely.
Ineffective, but that's what he's trying. Patrick, you make a fine point. We still haven't found the plaintiff, and that is going to unravel the state's case. It is.
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
All right, you got 2 more witnesses today.
My jurors need to stand. Go ahead.
Let's do it. Let's get it done.
It is impressive that it's all pointless, but you got to let the guy have his defense, and they've gone through a lot of witnesses. Given his delay tactics, they've gotten through a lot.
That is true. It has been efficient. It's because he doesn't know what to ask anyone, but, that's beside the point.
So much paperwork.
Kevin Campbell, absolutely. Ybor has some fantastic cigar shops. Not going to plug any because they're not paying me, but great place. I think it's the largest Cuban community outside of Cuba. I think he's going with a mistaken identity argument. I think he's trying to suggest that there were other people in the car and that he wasn't the one driving at the time, even though we have him on video.
Oh, good Lord.
I think that's where he's going with it. It's the only argument that he's kind of setting himself up for. It's not a good one. And it's pierced in a heartbeat.
Well, that and jurisdiction.
Well, there's that too. But, you know.
All right. Well, what happened here?
Fox decided to crap the bed.
Let me see. Let me see.
Yeah, I know he admitted that he was there. I get that. He has a very confused, kind of schizophrenic argument. There's no way to stitch this Frankenstein's monster back together.
All right, we're back to law and crime.
Ma'am, if you would please make your way to the witness stand. When you get there, please remain standing.
Yeah, there's that too.
Stand and
That doesn't particularly help.
left will swear you in. Go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to
There was an argument, but that died about 2 weeks ago.
I do. Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kathleen, Kathleen. Last name Urell, Yourell.
Thank you so much. Your witness. Go ahead.
Good afternoon, Miss Is it Urell?
Urell.
Urell.
You know, Gary, fun fact, I actually
What do you
think
do
that
for a living?
Ybor was the first
I'm in
Cuban,
workforce management for a call center.
but I could be wrong on that historically.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Partial meaning maybe a few minutes.
Until my group of children went by.
Okay. Do you recall where you were
Absolutely.
positioned
He wants to kill him.
during watching your group participate in the parade?
Yes, on north and east, right on the corner there. If you're going parade route, it would be on the right-hand side.
Just so we have clarification, can you pull up the exhibit? I believe it's 15.
Well, it's laying there every day. Thank you, Chad.
Thank you.
Go ahead. And thank you.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I'm going to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's
you?
not published. So do
Oh.
you want it published?
I'm sorry. Yeah, published.
Sorry, I didn't mean to interrupt, but I just wanted to point
So
that out.
just so I know.
Can we give her a
touch
crowbar and
has
see what
been
happens?
published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you, using the touch screen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching.
right on the corner. Sorry. Oh, well, if you want to
Can you clear?
erase it
Can you
again,
clear
I'll do it
the
again.
arrow?
We'll clear it. You can do it again.
Yeah.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna
Can you
say
clear
that.
Well, I mean, it was right there, but.
I was gonna say a circle or a little dot if.
Well, I thought I was doing that. But...
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
Thanks, Nancy.
And you said that would be approximately East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you
God
recall
help
if there were
him if
barricades
this is
at those?
the mother of one of the children that he killed.
We can take Exhibit 15 down.
Thank you. Go ahead.
Or a schoolmate, anything.
And you said you stayed at the parade until.
Let's say her child was the best friend of the 8-year-old that she plowed down.
And
why would you call this person?
what time did you leave?
I can't determine the time. It was right after my group of kids went by.
And where'd you go from here?
I walked down, well, I went to go get the car because I had to go.
Emory University. My
At
undergrad.
the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Grigori, absolutely
Not
right.
necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? That'd be fair to say first? I don't want to assume.
Yeah.
Absolutely right,
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Oh my God, he has such a
Nothing of that
punchable
nature.
face.
He really does.
Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car.
Thank you, Tammy.
Coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked
You
down
see anything? I
to
mean,
White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And At this time,
I
a
was not
car
aware of
was
your
beeping
particular involvement.
and weaving around a slight
That's
curve that
brutal.
White Rock has.
Why would you call her?
And then continued on.
It's a poor choice.
Did you see where? Did you see where the car went at that point?
Yes, I
No,
did.
yeah, honestly, no.
It came around the slight curve White
Daredevil?
Rock has.
Sounds good.
It started to move forward, and then it went straight across when I was thinking it was going to leave the parade route. If you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're
Well,
leaving
by
the parade
combat,
route.
let's just do it.
If you're turning right, you're going right into the parade, and it went right to the, if you're looking at the parade.
Anybody in
it's on the right-hand
Waukesha gets to take a crack
and
at
it's
him.
continued on into the parade.
Hold on, just for the record, she was using her hands
Yeah.
during her testimony. I just need,
Left.
that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record. Sure. Go ahead, next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, the horn was beeping.
Brian, if you don't like me talking, then
Do you
can
recall
pick another
if you
channel.
saw who
The
was
only person
operating
telling me to shut up
that
is
vehicle?
Mike.
Unfortunately, sir, I can't recall.
Do you
Long
recall if
crime,
you might have
Fox.
seen,
Those are the
multiple
feeds.
people
Go to
in the
'em.
vehicle at that time? Or-
Unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while. Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
Oh, that's awesome. Thank you.
Oh.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
Oh, believe me, I've heard it before many times.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have clipped me or the two people that were in front of me.
Where you were, the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Mr. Rell, thank you for being here. You
Oh,
testified
Kevin,
on direct examination
you know how I
that
feel
you
about
don't
tint. You know it.
recall whether or not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going. As to a lot of topic of conversations, I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Yeah,
Overruled, you may answer.
I can't be too sure. Overruled, she may answer.
Can you say that again? I'm sorry.
I can't be too sure, again, some of the conversations I might have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of East and Main?
Go ahead.
Thank you. Your testimony is that you were standing here on the northeast corner of Buckley and Main Street. Is that right?
Correct.
Objection already answered
Awesome
that.
sauce.
Asked and answered.
Nice.
Overruled, she may answer.
You said correct.
Correct.
And after your children walked by in the parade,
That's
you
right where
walked
I'm at.
in this direction towards the intersection
After a few White
of
Claws.
White Rock
That's
and Main.
right where I'm at.
Objection
Correct.
leading and speculative.
So overruled as to both, you may answer. If there is another objection, just.
I'll
wait
pause.
until I rule on it.
Sorry.
Thank you. No, that's okay. Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street, is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police officer being in that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was, very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes.
Did it appear to you as though the vehicle we've been talking about?
I know how sarcastic that is.
No.
How many children do you have, Miss Darrell?
Objection irrelevant.
Overruled. You may answer. Four children.
All four of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled, sorry.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay. You still need a 15.
Yes.
Fuck you.
You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry. Overruled. Again, sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer. I was only able to see two of my children that night.
When did you see the other two?
What the?
Days later,
What the
when I was
flying
able to
fuck do you think
leave
is
children to
appropriate about this? Calling this witness.
As their mother, you were
She
directly
handled herself
involved
so
in their medical
well.
care, and the decisions that were
On
made
Iraq.
in that process in the days after the parade.
I didn't realize how.
Overruled. You may answer. Yes, their father and I.
Charlotte suffered a
This
chip
is
vertebrae
literally just
being struck.
re-victimization. Oh my
Sure.
god.
Sorry, again. Overruled. You may answer. She did.
I'm amazed how well she handled herself on
Daughter,
direct.
she was 10 at the time, wasn't she?
She was.
Was
It's everything he deserved.
Chipped front teeth, is that
deceased.
Yes.
correct? And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
Apparently not
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the Extreme Dance Group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Yes.
And road rash?
Extreme road rash.
And a lung contusion?
Hi, Debbie. It's
Hey.
heavy right now. Heavy.
Great.
Facial scarring?
Just what I need as I'm getting into my car.
And your 7-year-old daughter, Vivian, suffered a broken tailbone, didn't she?
She did.
Your son, Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Overruled.
He was walking with the Extreme Dance Group handing out candy. Is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Was that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Yes.
I don't have any other questions.
Will you read the record?
No redirect.
Thank you, ma'am. You may step down.
Good decision, you freaking monster. I have no idea why on God's name you would call this poor woman.
So we're gonna take down these exhibitors and gonna stay up on there.
Thank you. We'll take it down.
Oh God.
Thank you, Debbie, for coming by, but you just happened to roll
Love
in.
you,
It was
Debbie.
the worst of the worst. It's a victim with her children who got massively injured in this. It was horrible.
He
welcome back
must
to
be a
Talk with Mike.
psychopath.
Yep.
Yeah, 4 hours in, 4 hours and 12 minutes in.
This is just the afternoon session. We've been here since 8:30 Central.
Oh my goodness.
Oh, it's been something.
People have been saying it. I don't know if it's the case, but it's basically he decided to call the rest of the prosecution's list because he didn't have any idea of how to call witnesses himself.
And they have not been helpful to his cause.
No, they have not.
So only one more person here, right?
It's my understanding, sir. That'd be correct, Attorney Hopper.
Yes, she's in the courtroom.
No, Deanna, he dug his own grave. He just used them as the freaking shovels. It was sick.
Can you?
Okay, defense calls Catrice. I don't know how to say the last name.
It's your witness, asshole.
Yeah.
I'm sorry.
That
I
last one was
looked
great for you.
BABIASZ.
Ended with the mother crying over your children, her children that you
What's
victimized.
your last name?
Mm-hmm.
Fabias. All right. Thank you. You are at the witness stand. Would you please raise
Oh,
your right hand? My clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Catrice Babiaz, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Babiaz.
Correct.
I'm surprised I got it right.
No, you're not. You're not funny.
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock Avenue.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn. Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand, waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way?
That doesn't matter. You still hit them intentionally, you freaking moron. I'm sorry. I'm just losing it.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Or I'll run you over because I'm a psychopath.
Back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
That's the defense. That's
I
what he's
looked
going to
the driver
argue.
right in the eyes.
And how did the driver?
It's not a legal defense. To intentional
The driver looked
vehicular
through
homicide.
me.
What do you mean through you?
Looked what?
What do you mean by through you?
I'll look through me.
I feel that it is very hard to explain that look, but it was very.
But I
frightening.
was honking is not a defense.
Right. I mean, is he thinking there's like a vehicle malfunction and he was unable to stop? So
Do you recall what the driver was wearing?
The driver had a like
When there's a
hoodie sweatshirt or sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the
Hold
vehicle?
on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from the driver. Thank you. Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
I'm not going to interrupt right now. Welcome to Log Talk with John. I'm not interrupting any of this. I believe she lost her son. So I'm going to shut up. I think she might be the mother of the 8-year-old.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
You can be a law enforcement officer and also lose a child.
I'm assuming at some point you spoke with the law enforcement about what you saw that evening. Would that be fair to say?
Yes.
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
All right, Thomas correcting me. I thought that a little bit by context, but still. All right, chat, I got it.
At what point were you not able to see the SUV once it passed you?
So unbelievably stupid.
I lost sight of the SUV once it went into a bunch of people.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, Do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
God, what purpose does any of this serve?
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Thanks, folks. I would be okay with it if there was a
Do you
rational
recall,
basis.
well, let me back up. Did you
Laws are always
leave the
fun.
parade at that point
At what point?
after seeing the vehicle?
Yes.
Yes.
For some, yes, absolutely.
Yes, it's not helpful to his defense in the least. She's back,
Were
baby.
you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
She didn't write the report.
Probably because I didn't tell anyone else.
If you were injured, why not tell?
Because you also injured my kids, asshole.
Yeah,
Sorry.
and like
Because I
a bunch of
haven't
other
might have
finished
had other
the
priorities at the
traumatic
moment.
experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't.
Jane, I swear to
you
God.
said you didn't know. You said it was that week.
Next person tell me shut up besides Mike.
The same week. You spoke with FBI agents. Reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say
No.
that kind of information would come up when talking to law enforcement, seeing as how you yourself work in law enforcement? It just seems odd, don't you think?
No.
I do not. I was not physically injured.
Oh.
Come on, buddy. Ask her the questions.
But you didn't report this at any time whatsoever. Grounds.
Sustained.
Asked and answered.
Already answered.
She didn't have direct physical injuries.
So
Doesn't
did you
mean she
speak to
wasn't injured.
anyone about this?
I wouldn't object to
law
this.
enforcement?
No.
It's fantastic
no.
for the prosecutor.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Thank you.
Did you
The idea.
Yeah, it is.
file any claims related to the incident?
No, I
Thank
did
you,
not.
Victoria.
Well, I mean, what more does he want from her, honestly? Like, none
He
of this
doesn't
is
want
helping
anything.
him.
He doesn't want anything.
Just
He basically
torture people.
he took the rest of the state's witness list that they did not call, decided to call them because he fired his counsel and he doesn't know how to build a narrative, and he's just torturing them one by one.
So today, your first time
Stop that.
bringing up your alleged injury?
Wait, what?
No, it is not.
Don't even ask. Don't even ask.
Thank you, Pats.
Just wrap it up, man.
This is the last
At
witness
some
for the
point,
day.
you were
Is it not?
subpoenaed by the district attorney's
It's got to
office
be. It's
testify here to
443.
to testify in this trial. Would that be fair to say?
Yes, it is.
And I don't think the state has any cross.
Subpoena.
From the district attorney's office, it was in July.
Tell John what?
And do you recall who you spoke with about the information regarding the subpoena?
Oh.
I contacted the victim witness advocate, Carrie Peterson.
Not all wounds are physical.
Mm-hmm.
You contacted the Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
Thank you very much.
This question's coming.
I don't know. He hasn't been doing that for the last couple.
You ever spoke with anyone directly at the district attorney's office?
Oh, here we go. All right. Yeah, it's coming.
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called.
So before today, you had no interactions with anyone related to the district attorney's office besides the, I think you said victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Doing their job as a victim advocate, advocating for the victim. That's what they do.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
I believe, just for the record, when you asked that, Attorney Basie was just pointing to herself and the two people next to her, so it's clear. Because
That's a good point.
What would be the reason for that?
Since there's
I
two
think that
individuals, I
he's
think
trying to imply that the victim's advocate coached the witness
wanted to
on
point it out
behalf
for the
of the state. which is ridiculous and stupid.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
Does that make her an expert now? That's nice.
I have not been in a trial for law enforcement. No, I have not.
Isn't she a
you've
dispatcher?
never-
Did they say she's a dispatcher?
She's in some sort of back office role. I don't know precisely what.
I have not.
Have you ever testified in any way before today? Rounds.
Oh my
answer.
I have testified before, yes.
She's a professional witness, is
So
what
it
you're
would be
saying, right?
fair to say that you would have knowledge of where
No, she's never testified before. She just said that, idiot.
in the courtroom, correct?
Referring to him, not you, obviously.
I know where they're sitting, yes.
Yep.
Want to back up a little bit to the observation.
No, please stop backing up. You don't know when you're going to hit a wall.
First 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position,
She's not entitled to give opinion.
did it appear that the vehicle attempted to strike anyone?
They're not going to object.
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching,
when it was
question
a,
was when it was approaching.
I'm confused.
Hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question that as you understood it.
Yep, so I saw that an officer have to get out of the way. And he was attempting to stop Mr. Brooks from driving through the parade. And he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr.
Sounds like you're
Brooks
resisting and
for the
obstructing.
first time that you've been testifying. Would that be fair to say?
Felonious assault.
I don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed?
Is your best handy?
Didn't like that, did you, dummy?
I don't understand your question.
You just stated that you didn't mention the name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
Oh, God almighty.
I don't know.
Every one of these witnesses has been so sweet and so honest under the tirade of this idiot.
I mean, he's lucky she doesn't jump off that witness stand and choke him out, honestly.
Yeah.
The guy yesterday, I think, was about to. I'm hearing the fax machine tone going through his brain right now.
Out of curiosity, how did you
Okay, if your question starts with out
come
of
to the knowledge
curiosity,
of that name?
Yeah.
It was on the subpoena I received last week.
You just stated a little bit earlier in testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
I mean, she could just
So
ID
you
him as the
received
guy
two
that she
separate
saw
subpoenas?
looking
Correct.
through her.
What was the
She was
difference
just-
between the two?
she
One
was
was
subpoenaed
from
by
the
the
district
state
attorney's office and one was from
originally,
you.
was not called, and he subpoenaed her.
So
Right,
the
she got
one
two
that you
subpoenas.
received from the
He
district
subpoenaed her
attorney's
as a
office
witness.
in July didn't have a case caption on it.
Okay, what's a case caption?
In fairness, I didn't know that until I started as a paralegal. I didn't know what that was called.
Just
It's
one
a
second.
technical term.
1 second, Your Honor.
It literally is just X versus Y case number.
There was
That's
no
your
objection at first.
There's that.
Would it sustain the
Yes.
objection under 906-11? I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need
I
to
don't.
ask your question directly, sir. Go
Yeah,
ahead.
he's going to the
Sustaining
freaking
is the form
subject
of
matter
question.
jurisdiction. He's going to say the state of Wisconsin is not an appropriate party as a complainant. We've been through this a million goddamn times.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection relevance.
Grounds.
Sustained, you don't have to answer that. I sustained the objection on that, those grounds. Ask the question I believe that you're trying to ask, not that one.
Was the name that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
Objection relevance.
Grounds.
Sustained,
Grounds for the sustained. That
not
was
relevant.
what?
Grounds for the sustained. That might be the shirt.
Danny, fuck off. I'm talking during the breaks and commentary.
Sir, in July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection relevance.
Grounds.
Sustained, not relevant.
She's testifying in the trial that's not relevant that she got subpoenaed.
Mr. Brooks, she's here under your subpoena.
He's gotten awesome since he left.
You called her as a witness. It's
The
your
subpoena is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
906-11, please ask the witness a
This is
relevant
mine,
and probative question.
This is mine, by the way. Mine, by the way.
Remind the jury that the statements of the parties or the attorneys are not evidence.
He's going to have an explosion before they hit 5 o'clock. That's what's happening.
So were you aware that it was a chance
And
you
we're gonna be here for
possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained,
Grounds for the
relevant.
sustained.
it's not
I've
relevant.
never heard
Grounds
of
for
nobody
sustained.
testifying in a trial that they didn't know who the trial was for.
He's setting up a freaking showdown
Sustained
with
the
the judge.
objection under 906-11, and I'm asking you to move on.
Y'all, this is ridiculous, man.
He realizes he has 5 minutes left today. And he might only have tomorrow, Monday. And he's setting up a fight for maybe another 25, 30 minutes with the judge.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
No, it's not.
Objection argumentative. Or no.
So the subpoena that you got last
Good objection.
that how you learned the name that you used?
Objection.
Grounds.
Relevance for the same reason I argued before.
Grounds.
Objection argumentative. Mike, you had to write the first time.
Indicated the answer already. 90611, sir. Next question.
The question
Different
was,
topic.
is that the first time that she saw the name?
It's not relevant.
That
Next
was not
question.
asked to answer.
Right. And then it was objected to.
That was
The
not
objection was
asked nor
sustained.
answered.
So shut up.
90611, please ask a question, sir.
Yeah, what is y'all keep trying to pull?
Yeah, the ruling's been made. Shut
Mr.
up.
Brooks, if you
Stop
don't
arguing with the judge.
relevant and probative under 90611, then I
Your
will.
opportunity to
turn
argue
the
with the judge
witness
before
over
the
to
ruling is
state
made.
for cross-examination.
And then I should be able to get redirect, right?
Sure. They're not going to ask anything. There's nothing to redirect if they don't cross.
Ask a question.
I think that's what she's setting him up for. It's
Declare
good.
the
She doesn't know for sure, but
examination
that's likely.
By you to be ended.
It's not an examination, it's direct.
It's the direct examination, sir. Under 90611, you are directed to ask a question, or I will ask the state if they have any
He
questions.
knows the state's not going to cross.
Thank you.
Hi, Lori.
Next question, please.
Wow.
Wow.
Sounds like we're just picking up where I left off here, huh?
Yeah.
Yeah, we
Still setting
moved
it down.
the needle nowhere.
You know who the plaintiff is in this matter?
Yes,
Who's the plaintiff?
the state of Wisconsin.
Is that an entity or a living human being? Grounds.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
Objection. Vague.
Sustained.
Vague.
As to the form of the
Have
question,
you ever had any interaction with the
Jedi
state of
robe?
Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Was there an objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir.
There's objection that was sustained. Ask another question, dummy.
If you could think of one.
Mr. Brooks, ask your next question.
Let's get to it.
Thank you.
Oof.
Wow.
Oh, he's gonna do
Ooh,
that shit
lip
again.
quiver. That lip quiver. Did you see that?
Oh, God.
He's getting sharp with the judge.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
He might in a civil suit,
Grounds for-
but he doesn't have any goddamn money.
90611, sub 1, sub A, sub B, and sub C.
Not that you can read, but there it is.
Is that lawful law?
All right.
Yes, yes,
Now,
those are actual codified
It's
statutes.
lawful
You
law, bitch.
fucking moron.
Yes, it is.
Is the DA laughing there? What?
She gave you the freaking book of evidence
Like to the
3 weeks ago.
to the point.
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course it's gonna be overruled.
3 and 6.
And I don't know, Mr. Brooks sits it down. I'm kind of asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the question.
No, I don't need a punching bag.
I would ask you to sit down,
Bracket.
please. It is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
Well, you're getting yourself convicted, which is
Oh
nice.
wow.
And when you were at the parade on November 21st of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered it does not mean the state doesn't get to follow up on it.
So, The state can ask the same question I
The
asked.
state can ask.
They
their
can ask
question.
what they want
Go
to.
ahead.
And I
Yeah.
did that. It
Overrule,
was
the witness may
it was
answer.
insane.
They can't axe it twice.
I
That's how
was
it works,
on
buddy.
Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I'd ask that the screen be cleared. And ma'am, does this show?
Wait till it's in the jury box.
sorry.
I'm sorry. The jury would let me know when it's there.
Oh, thank you. And I don't know.
There now, go ahead.
Ma'am,
Sounds like
do
you're
you
on the
see
law nerd
line,
path.
that would indicate the parade route going from White Rock Avenue down Main Street.
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Ask the answer.
Overrule, the witness may answer.
There were barricades that were partially blocked. They were on Main Street, but partially blocking Pleasant
Mostly
Street as well.
lawful.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overrule, the
Hearsay.
witness may answer. It's not hearsay.
So when the red
Yeah,
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
It's hearsay. She's speaking as a
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness
As
may
usual.
answer.
It's always overruled.
Go ahead,
We'll make an
answer.
appropriate objection.
Sorry, there's a
That would
lot
be nice.
talking. Your question
You were
was,
capable
just
of
to
that.
clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection. That's mischaracterization of what was testified to.
Overruled. The witness may answer. Go ahead.
It's the same witness, you idiot.
Can you
It's a
repeat it?
question.
Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay, you weren't part of the
Couldn't
parade.
say
correct?
no.
We were not.
Okay, so were you standing with other people that were in the roadway?
Yes,
You
we were.
weren't.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection.
daughter.
Speaking as a first-hand eyewitness.
Oh, dear God.
Because she is a first-hand eyewitness.
She is.
Witness.
Um,
That's why she's speaking
That's
as
literally
one.
what a witness
objection is noted.
means.
It's overruled.
What is
Question
wrong
is
with
proper,
you?
And the witness may answer.
Troglodyte.
He's
My
getting-
daughter was,
He's
further
getting
in
more
the
and more
roadway,
desperate. That noose is
realizing
tightening,
that the
man.
day is
reaching to
ending.
grab candy.
At any other time, you said that this was towards the end of the parade.
What do
is
you
that
think
correct?
a witness is?
Yeah, we saw Santa, and he's always like the end of the parade
And had your daughter gone to get candy at other times?
the entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled. The witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection. Speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red
I
SUV.
actually don't understand why the prosecution
Yeah.
is crossing.
Describe that for the jury.
Well, there was a few times that police officers attempted to stop the red SUV. The first one was
I do.
again,
This is devastating.
where we were
I mean, it is.
on Main and White Rock.
They don't
and
need
then
it,
there were
but
also other
She was
people trying to
devastated
hand it
enough
to
on
us,
direct.
sure.
Might as well
and
take
then
it.
a guy as
Yes.
Yeah.
once it turned on
My
to
Jimmy
Main,
Neutron going
the
on
next
here.
road, I believe is Buckley, and there was another officer who tried to stop that the red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to
That's
step
not
out
a
of the
bad
way
theory
to
either.
avoid being struck by the red SUV?
I believe that was the officer around
That's the
Buckley
more generous
and Main.
approach.
And ma'am, as the car passed your location, did it increase its speed?
Aw, thanks, Georgia Peach.
Know where in the roadway it traveled down?
Overruled. The witness
Yeah, I
may
agree.
answer.
Jimmy Neutron was one of
The
my
direction
favorite
of
shows
travel?
as a kid.
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you
Dri-
describe to the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Yes, Cordoba.
Nothing further.
Thank you. Can you redirect her?
Yeah, but now he gets to redirect it. He has a little bit of scope to work with.
He doesn't know that.
Yeah, but the judge has been letting
I
him
agree with
get
both of the
away
prior
with
statements. I had both of those thoughts exactly. I'm like, thank you. That's why I have guests. I don't even have to say anything.
Describe one. That, I think you said it was Buckley, right?
Yes.
Yeah, fair enough.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
Nino Shuffle. Yes.
I don't know what you're asking.
I was literally hit by a car walking across the street last December. Yeah, it's not a fun experience.
FBI. That was who did your interview, correct?
Yes.
Yep.
Why was there no?
I'm just grateful I
why was there no
lived.
report about the multiple officers that you
6
say
people
saw
in this circumstance didn't.
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that some details you don't quite recall all the way. That be fair to say?
Yes.
So it would be fair to say that if there's details you don't recall, how can you recall path of travel of the SUV that you claim you saw?
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall. So would it be fair to say that you don't quite recall the path of travel of the vehicle?
No, that is not correct.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So
Good
you
answer.
recall all the details of what you observed that evening, November 21st, 2021?
No.
I'm not sure this is within the scope of the cross.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, what are the unknown unknowns?
The question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not.
Objection, badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue. What do you mean?
Oh, here
Next
we go.
What do you mean?
You're in Wisconsin. You should know what badger
The witness
means.
is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding
Does
her
she
answers
feel intimidated?
is badgering the witness.
Are you kidding me?
Under 90611, please ask your next question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
She just laid it out for you.
Badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611. Please ask a question or I will stop the
How
questioning.
did I intimidate?
Under 90611, sub
You know
1,
exactly where this
sub
is going,
8,
Judge. We
sub
did
Asked and answered.
your
Judge,
next
don't
question,
indulge him.
or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right, you may step down, ma'am. Thank you.
How are you even a judge? Come on, man. This must be all about the substitute trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented. And I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking.
How much of a
sites
disaster
to
do you think it'll be
receive
before
any
they drag him
information
out of the
about this
courtroom?
case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation.
I'm worried that might be the case.
Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party.
It feels like there's no empathy or soul behind those eyes.
The courtroom could be misleading, inaccurate, or incomplete.
None.
Relying on this information is.
I want to see if she walks out on him or if she tries to engage him right now, which would be a
Do
mistake.
not communicate with anyone.
I think
about
she's
your
gonna make
experience as a juror while you are serving.
Make
on
a
this
record.
jury. Do not use a
She's gonna
computer,
try and
cell
make a
phone,
record,
other
I believe,
electronic
because
devices,
she ended.
She needs it.
She ended the questioning.
tools with communication capabilities.
They need a trap door.
You think about it over the weekend. We'll take it up on Monday. Bye-bye.
Text message, instant message.
That would be a nice way to handle it.
Any other way, on or off the computer. Do not permit anyone to.
And again, I like this judge. I think she's trying to do the right thing, but I think that she walks into his trap so frequently.
Please report that to me. I appreciate that it's tempting when you go home in the evening to discuss.
I've certainly seen it the last 2 days.
May not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations.
I was
and
thinking more like
decisions.
trapdoor, like what is
After the
it?
trial is completed, you are free to communicate with anyone.
What was that game show network?
These rules are intended
Oh
to
yeah. And the judge can just push a button. He just falls to the floor.
Yeah.
Another has violated these rules. You should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report.
I think she's going to try and make a record after the jury leaves, and it's going to be absolute
I've
mess.
cut off too early a couple of times. I'm going to wait a second to see.
Mike, are you going on with Natalie after this? I got the link.
No, I'm going on with you.
I figure I might as well just go on with her at this point.
Integrity whatsoever.
Oh, good Lord.
Oh, shut up, dude.
Well, then we'll do it
You're
tomorrow.
not helping yourself.
Yeah, we'll do it tomorrow.
None.
Thank you, everyone. Please be seated.
Yeah, she's going to make a record. Oh, my God.
Yep.
I called it.
Get your popcorn.
I would like an update on whether Mr. Brooks filled out a subpoena for Don Woods and provided that to the state. Has that been done?
We haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary.
It's
We
regarding
had
the mother.
subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice.
Gracie, that's our
But
secret.
Our
She's
position
gonna love it,
would be,
though.
Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just
that
know that.
Oh, yeah. You're the
she
man.
could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She don't come.
Yeah. He's got his mom under control.
All
like
right.
that.
Well,
Mr.
there
Brooks,
you
you
go.
intend to call her as a witness.
What do you think, Mike? Do you want to start it like 6:30 and
Like, I don't even want
do
to
it
be
tonight,
here that
or
much longer. Just do
save
what
it
you
for
got to do
tomorrow?
so I can get up out of
Your
here.
call.
I'm tired of being in the courtroom that has no
Just asking.
integrity whatsoever. How can you even call yourself a
Mr. Brooks,
judge?
I need to make a record of
I
some
need to
things.
make a record too.
Tough
You don't
shit.
When am I gonna get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not
Yep.
going to let me make a statement or make the record that I need to make.
I'm finna
He
leave
hasn't
anyway,
sat
so what
down
do it
for
matter?
the
You can
better
hold me
part
in
of 2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you in
gotta do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom
coming.
because
You
I
gotta
do
stop
need to
explaining
make.
to
What
him.
you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some things
If
on
it's
the
civil,
record. The record should
where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what is
He is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the
Step
next
off.
courtroom.
trying to address
Yeah,
me
step
like that,
off.
like we cool. You don't have
Step
no
off.
integrity. How can you
It's like
even
the
call
episode of
yourself
Seinfeld.
extremes, being biased, judicial misconduct, trying to steal somebody's system?
Steal somebody's what? What, they cut off his microphone?
He's trying to steal
accusing her-
somebody's what?
Beautiful.
No, they cut it off.
You know how I feel about this?
Say a word. Oh, and go ahead and put yourself on mute now.
That's how I feel about that.
Oh Lord.
That was
Wow.
that was a supreme shit show. Thank you all for joining me again.
But it's like that dog, you know, that gets cornered.
Yeah.
Gets vicious. You know, this is it. He's like, you know, it's winding down. He doesn't have anything.
No.
I think that's, you see this, man, dude. You can. He's not doing himself any favors. The jury sees this. They say, yeah, this is a dude who could run over a parade ground full of innocent people celebrating Christmas.
Well, I think the
Kids
jury
dance on
was
grammar.
at that point when he had the actual outburst.
You
They're
know,
not
and
done. You want me to go back there? All right. Well, they're not done, but this is what's going on right now.
I told Secret I'm going to schedule my thing for 7. Let's just get it out of the way tonight.
7 your time?
My time. So 6 your time.
All right.
That work for you?
All right. That works for me. Go do what you gotta do, brother. Go get that put together. 7
It'll be
o'clock.
quick.
What's it called? You have a thumbnail?
No and no.
Well, then get the hell out of here and go figure it out. I'll hold this down.
Nah, this is more fun. I can do both at the same time.
You can? I can't.
Yeah.
Oh my god.
Right now I'm thinking lawyer's letter and general commentary.
All right. It's all good. Well, that was a nightmare. Okay, so she's gonna come back. I've got it on. So if it pops up, I should hear it.
And
so, are there any other witnesses left besides Mommy?
I believe
Well, is he going to testify?
He's going to call his mom to testify. His mom is going to say he's insane.
That seems about right.
Mm-hmm. Oh, thank you. Mom's
Wow.
going to say he's insane, and that is probably the best approach he's ever had, but he screwed it all up by passing a bunch of competency evaluations.
Yeah, well, I mean, again, I think that the temporary mental... I genuinely think you could have brought the murders down to manslaughters. I think there was a way to do that. I just think he screwed himself on that front.
And yes, Peggy, my mom will show up. Moms always show up. They're the best. Mom will show up and do whatever she thinks is best.
Well, I don't know. He apparently thought that he needed to subpoena her.
How great would that be if she didn't show up after she didn't have a subpoena, and after he's saying that she'll show up if he says to?
This case is so awful, but you still find the humor in it. And the guy flexing about getting his mom, he's like, if I say for her to be there, she'll be there. Yeah, dude, it's your mom.
Yeah.
It's not like a big thing to say, you know? I mean, yeah, some people have horrible mothers that wouldn't, but most people don't, you know?
Yeah, that's fair.
Oh, good Lord. And frankly, that just makes your actions all the worse. So you had a decent mother that supports you, and you act like this.
Yeah, that doesn't exactly help you.
Thirsty girls.
Thirsty girls. Who doesn't love thirsty girls?
Here, Mike, that's the link for 7 o'clock. And it's just going to be going through that letter that I shared with you. And I'm going to go through, it's like 3 paragraphs on one of my favorite cases. And that'll be about it. It's just kind of a palate cleanser after all of this nonsense.
Fantastic. We'll do it. All right. Do you have Ben? Do you have anything we need to know about out there?
No. Everything's great at the jail.
You know, Hilligus and Hanty, which I know is not a case you're working on, but you just are you know at least some of the attorneys involved.
Oh yeah, the one out in Reno, right?
They found him. That's going to be a mess.
We're back. Verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that,
is he
I
reading
need
his
to make
Bible?
a record that at
Ignoring
the very
her?
end of
probably
after I read the
oh good Lord
closing instructions, Mr. Brooks started to make disparaging
Sock
remarks
puppets.
about the court in the presence of the jury. I did not respond to those, and once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. And it was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11 sub 3 to be exact, for the state to ask leading questions.
Yes.
Which they did.
Wait, on cross you can ask leading questions?
And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given or the court sustaining the objections, that is why I made a finding at that time and sustained the objection for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday uses, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off
It's
the
contextual
examination,
with other behavior.
which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, or relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures.
We have like over 4,000 people right now watching this.
Wow.
He did not like her testimony. And again, I'd remind everyone that it was his witness. And he had the police reports for this witness. And obviously was
you brought this on
yourself. A debacle from his perspective.
To the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through
Argentina won Copa America last year.
We have gotten through
ended their drought.
Witnesses,
that's what that is.
Very cool.
For which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which there is, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I want to put on the record, and what I will put on the record, are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment,
everybody already hates you,
are as follows. Mr. Brooks has a constitutional right to testify.
He does.
If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still
Oh, it
need
will.
to make a
He's
ruling
gonna
on that, and I will
testify.
do that first thing Monday
It
morning.
will include that.
I will also
It-
advise
Don't
him
forget-
that he has a constitutional right.
And he can
not
only
to
testify as to things that are relevant.
that a decision not to testify, that a jury will be so instructed, not
When they say anything
that-
you say may be used
they
against
will be
you in a court
instructed
of
that
law,
that cannot be used against him.
that may
and
is it
there's an
will.
appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility
just
of any
different
other
standard jury
witness. There's
instructions.
the added paragraph to jury instruction 300. I would
Lee
further
sounds like Lee. I don't
advise him that it
have a
is
channel.
his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises.
He doesn't know how to
him
argue
in his
jury
decision
instructions, so
to
just submit the
testify.
standard and call
I,
it a day.
Will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings.
Oh, that's awesome.
I will then ask him
He's
whether
gonna
he's made a
confirm they
decision,
can read and write
ask
English.
what that decision is, and then based upon his decision, I of course will make an appropriate
I'm
finding.
sorry, that's just too funny.
Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or
I'm sorry, that's just too
Mr.
funny
Brooks
for me.
sometimes raises. I'm also going to advise him today that failure to answer the question on what is your decision.
Oh, the colloquy is coming now.
Failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so
No, she was saying
instructed.
She was saying
And I may ask that question more than
he had
once.
time over the
depending on
weekend to do it Monday morning.
circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony.
He is in killing people with power.
Scope
doesn't ask anything.
of it, Chambers versus Mississippi.
It depends
the
on what
US
he
Supreme
says.
Court case from 1973, found at 410 U.S. 284.
He's been very good
Ruck
at kicking
versus
open doors.
Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20.
Yeah, like that's going to make
These
a difference.
cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense. Of course, that right stems from various constitutional provisions, including the 14th Amendment, which protects a defendant's due process rights to be heard and offer testimony, the 6th Amendment, which protects a defendant's right to call witnesses in their favor, and the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004, Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146, Wisconsin 2nd, 315. Moreover, a criminal defendant's right to present relevant
You may
testimony is
try
subject
to
to
cut off
reasonable
the subset,
restrictions.
but the subset
Citing
is
to
just
Rock
travel.
versus Arkansas, there's a balancing test that if and when this court is faced with any of these
That's a
situations,
good question,
that I will be
Leah.
prepared to go through.
And so it begins.
Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 90611. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is
I
a
know,
secondary
people.
objective of trial. But
I'd like to see this
And of
done
course,
by Tuesday or Wednesday.
it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving.
I'm not dealing with it. She's gonna say
No.
a few more things, but she's gonna take forever with it, and we get the point. He's not gonna come back on Monday morning. He's gonna make a decision about testifying. It's gonna be him, his mommy, maybe one other witness. I missed right there.
Yeah, that sounds about
I mean,
what I heard.
Do you think he can resist?
The state's gonna Ben. How long do you think they give for the state? This is what I can't figure out. They got to play some video and stuff. How much do you think they give the state? This is 6 people who died, 60 people injured. How much do you?
How long has this been going on? I've only been catching this week.
This is the third
3
week
weeks.
of the trial, I believe.
Right. So, oh man, I would think
half a day.
At least you do. Yeah, I would say half a day at least. At least 4 hours. It could be
And
more.
then
Yeah, for sure.
He doesn't have anything to say because he's stupid.
I
Okay,
know.
but he will waste half a day.
Yeah.
I mean, he'll say he'll get cut off and get frustrated, and this is why when he testifies, I mean, I'm assuming he's going to testify. I don't think he
Right.
could resist the temptation.
Right. I think you're right.
Not to testify.
I
So
think you're
he's.
But you figure the defense case, if it's just him and his mom on Monday, that's got to be the end of the defense case.
Right. So then so this thing probably gets to the jury on Tuesday. Maybe Wednesday.
I don't know. I think maybe
If he
Wednesday.
filibusters for a day.
Because I think the state, because of the way that they set up the timeline argument without publishing, I think they want to play a lot of media.
They might do a whole
I'm
day
thinking
on
they're
closing
gonna
argument.
take-
I don't know if a judge will let him do that much.
Yeah, I think they're going to take
That
the better
hurt.
part of it.
They gave him a couple hours for closing, and that was it. On a 6-week trial.
Yeah, that's true.
No,
I don't know. I could.
You can't testify on direct and then take the fifth on cross. That's the whole problem. Or everyone would do it.
No, you cannot.
But I mean, it's a good question if you just want to be
It
explicit.
is a good question, but the answer is no, you cannot. I think
I don't think that should stop him from trying.
he's gonna try.
He's gonna testify, but that's the problem. If he testifies, I mean, mom's got nothing to say.
No.
Of relevance to this thing, other than he's a good boy, and now I think he's crazy. That's what she's gonna say, no matter what he asks her.
But that's why Florida separates trial from sentencing in just totally different procedures.
Well, yeah.
I know that's irregular compared to the rest of the states. But you're making a sentencing argument. You're not making a guilt argument.
No, but he's going to get, and it's going to get just crazy because he testifies. He's going to get shut down every 30 seconds over relevance, over whatever, something that's not proper.
Yeah.
And oh man,
it's going to be a nightmare.
And he's going to blow his top. I mean, he's already reached his boiling point. So
what could he possibly say that would comport with the rules of evidence that is true and won't immediately be damaging to him?
He could. Okay.
Georgia.
What can he say? What to testify?
Yeah, presuming he's testifying, what could he possibly say that would not immediately get thrown out?
I wasn't there. I was in another location.
Okay.
No one will believe it. But if he starts
testifying, it wasn't me. Right.
On the date of the alleged incident.
The Shaggy defense.
All right, pull the Shaggy defense. Cool. What else?
I mean, it won't work. It won't work. But you've got to let him say it.
Was this or was this not you on the camera?
I get it. I get it. They can put him there. But you'd have to let a defendant facing 6 consecutive life sentences say his obvious lie. But you have to let
say whatever
him.
he wants, but who cares? And
No,
how
yeah,
long is that
honestly
honestly
gonna
going to work? How long
That's why
is
he's
that
going to get
officer
shut
going to
down,
take?
and it's going to be another
I haven't even looked. I don't know.
outburst.
I don't even know. I'm guessing I'm gonna do this on Monday because I've been with it this long, but I don't know if I've got something that I can't get around. I've been pushing things around.
If you don't, we'll be in touch, and I'll pick up.
We'll figure something out. All right.
Yeah, whatever.
Ben, how are things over at the jail?
They were great. Everything was great.
The upside of that is you know where your clients are.
Yeah.
You can get a hold of them.
Yeah. Zero client control still, but yeah.
Zero client control.
Do I want
We're
to?
still operating on zero client control.
Yeah, well.
Yeah.
That's why you have clients.
You know,
it's gonna happen. All right, I'm gonna lose my mind. I've got to I haven't eaten. I did not order Uber Eats. I gotta throw something.
Dear.
I
All
gotta
right,
throw
you
something
hopping
in
on
my
at
mouth.
7, Mike?
What? I
You
will be
hopping
on
on
at
at 7?
7.
All right.
Thank you guys. Thanks everybody for coming out. We're gonna close this one down. We'll be back Monday one way or the other. I will figure it out and tell you all. Thank you, Ben. Have a great weekend.
All right. Bye, everybody.
Thank you, John.
Bye,
I will see you in a little bit. All right. Bye.